Thank you, members, for your attendance this afternoon. And just to advise members that they are welcome to use the mobile devices that are as long as they are in airplane mode, and all devices are muted. This includes members' tablet devices, and they can connect to the Assembly Wi-Fi. Also, to remind ourselves that we are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to the matter under consideration. Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises during the meeting. Can I have agreement for members of the committee for the committee's consideration of the amendments to the Justice Bill to be provided for by the Department of Justice to be recorded by Hansard? Agreed? Agreed. Agenda item 1 are apologies. I have an apology from Emma Rogan, and Peter has to leave early. We also have an apology from Robin Newton. And also just advise members that Rachel is joining by Starleaf, and we also have Gemma and Sinead, the Deputy Chair, all on Starleaf. So you're all welcome. Just again, in regards to the delegation of votes under Standing Order 1156, Emma has delegated her vote to the Deputy Chair, Sinead, and Peter has delegated his vote to myself. Robin has delegated his vote to myself as well, and Sinead has delegated her vote to, plus Emma's vote, to Gemma when she leaves at about 5 p.m. Agenda item 2 are the draft minutes of the meetings held on the 15th and the 17th of February, respectively. You'll find those at pages 5 to 7 of the meeting pack, the draft minutes of the meeting of the 15th of February, and pages 8 to 21 of the meeting pack of the draft minutes of the meeting held on the 17th of February. Are members content that the minutes are a true reflection of the proceedings of the meetings held on the 15th of February? Agreed? Agreed. Are members content that the minutes are a true reflection of the proceedings of the meeting held on the 17th of February? Agreed. Agenda item 3, matters arising. Items 1 to 3 and item 5 in relation to the commencement of provisions of the Domestic Abuse and Civil Proceedings Act. And members, I would refer you to pages 23 to 33 of the meeting pack and page 4 to 14 of the table pack. The letters from the Minister and her written statement to the Assembly were also emailed to members upon receipt. The Minister of Justice has written outlining the arrangements for the commencement of the main provisions of the Domestic Abuse and Civil Proceedings Act, including the new domestic abuse offence coming into operation on the 21st of February. A copy of the written statement to the Assembly on the new domestic abuse offence, the commencement order, have also been provided. The Minister has also now confirmed that Section 28, providing a waiver of the legal and financial eligibility test for victims of domestic abuse who need to respond to an application by their abuser under Article 8 of the Children's Order, has been commenced on the 22nd of February. And the Minister has provided a copy of the guidance to the Director of Legal Aid Casework on the implementation of the waiver, which sets out the evidential test that will be used to enable people to demonstrate their eligibility for the waiver. It provides the approach to determination of the contributions payable to beneficiaries of the waiver and the provisions covering prohibition on cross-examination and special measures in the family and civil proceedings that will be commenced at a later date. And it's for members to note the commencement of these provisions unless there is any further information or clarification that is required. But I think it's welcome news that we have seen the commencement of these particular elements. Rachel?
No, Chair, it was just to share those sentiments. It's just really good to see last week the commencement of the domestic abuse and coercive control criminal offences, but also with the Section 28 being commenced as well. I just think it's a good week for especially the amount of work that has gone into getting us this far. It's good to see this side of Purda.
Yeah, thank you, Rachel. And can I just sort of pay tribute to previous committee members and to the staff who worked, including Rachel and others who worked extensively hard in regards to ensuring that the bill was brought to the House in the way that it was, and now we have see the commencement order. So I think it is an evidence of the benefit of having these powers within the Assembly. So a word of appreciation to everybody who was involved. Item 4, the Committee for Agriculture, Environment and Rural Affairs, is the response regarding the domestic abuse information sharing with schools regulations Northern Ireland 2020 Operation Encompass. You'll find that at pages 34 to 37, and as part of its deliberations on the proposal for the statutory rule to provide an Operation Encompass model for Northern Ireland at the meeting last week, the committee noted that the Committee for Agriculture, Environment and Rural Affairs, the Committee for the Economy and the Committee for Education were supportive of the introduction of the model. The Committee for Agriculture and Environment and Rural Affairs has now written providing further information the potential training implications for the College of Agriculture, Food and Rural Enterprise and the establishment of protocols with the Psni that it has obtained from the Department of Agriculture, Environment and Rural Affairs. And it's for members to note the information. The committee agreed that it was content with the proposal for the statutory rule last week. Item 6 is a committee visit to the Psni Cyber Crime Unit. Just to advise members that the agreed visit to the Psni Cyber Crime Unit will take place on the morning of Thursday, the 3rd of March 2022. The programme for the visit can be found at page 15 of the table pack, and I would ask members to confirm as soon as possible whether they are available to take part in the visit so that the Psni can finalise the arrangement. And if you can let the clerk know, then that would be very, very much appreciated.
I hope to be,
yes,
hope to be there. Yep. Just 100% confirm the diary, but yeah.
Okay, thank you. Agenda item 4 is the Justice, Sexual Offences and Trafficking Victims Bill, consideration of the text of amendments provided by the Department of Justice, and you'll find that members at pages 39 to 114 of the meeting pack for the relevant background papers. The text of the draft amendments to Clause 1 and are for an offence of cyber flashing and information on the position regarding the corrective amendment to the Committee's amendment to what is now Clause 5, almost previously Clause 3, provided by the Department of Justice, can be found at pages 24 to 40 of the table pack, and it was emailed to members yesterday. Further clarification was requested from the Department regarding the position in relation to a corrective amendment to Clause 5, as it was the Minister that indicated during the consideration stage debate that there was an issue with the committee amendment that needed to be fixed, a fact that has not been brought to the committee's attention before. The commentary in the letter and Annex 2 from the Department did not provide sufficient clarity. So further correspondence was received this morning and can be found at pages 21 to 23 of the table pack. Further letter received this morning providing the text of a number of minor technical amendments is at page 17 to 20 of the table pack. The departmental officials are attending our meeting today to assist members' consideration of the amendments and answer any further questions. And can I, on that note, welcome Brian, the Deputy Director of Criminal Justice Policy and Legislation, and Lorraine, Head of the Criminal Policy Department, Policy at the Department, to the meeting this afternoon. You're very welcome again to the meeting. It's becoming a regular occurrence. However, I think we're coming to the end of this particular process, and also just to advise you that the session will be reported by Hansard and the transcript will be published on the committee web page. Just to advise members and officials that we will deal with each of the amendments in order in the Department's correspondence dated the 23rd of February. And we will just ask Brian to make some comments.
Right, thank you very much, Mr. Chairman. I think we're getting towards the end of the road now, insofar as when I was here with the Minister a few weeks ago, and the committee decided to withdraw a couple of amendments at consideration stage. At that time, the Minister offered to work with the committee to actually address both the voyeurism amendments and the cyber flashing amendments to try to do our best to take on board and into account what the committee had highlighted as its concerns, while at the same time drafting it in a way which actually was consistent with good practice and good legislation. The first letter you got on the 23rd was very much focusing on the voyeurism and the cyber flashing. That set out some of the considerations we'd given to this in light of the committee's advice. And it also took account of the meeting I had with the committee last week, where we trailed a number of the options we had available, and we took the committee's soundings from the committee and advice from the committee as to its preference where those options were available. And on the basis of that, we have worked very closely with our legal team to draft the revised amendments, which we've now presented to you as an annex to that first letter. So I suppose the first question for the committee is looking at those new draftings covering first of all the voyeurism, and secondly the new cyber flashing clause, whether you are content that the amendments which we have made are sufficient and actually meet your requirements. Okay. I would add we have still, if there were any minor adjustments or if there were very serious adjustments, we may have some problems. But we had our lawyers working all over the weekend to produce these. But certainly, if the committee finds there are elements which it feels could be drafted better, we might still have some opportunity to make further adjustment.
Okay. If we can we take them in the order of cyber flashing and then clause 1? And we'll deal with
the way they're presented.
If that's okay.
Fine. So on the cyber flashing, essentially the main element was actually include a recklessness component, which was linked to obtaining sexual gratification. That was it. That's in 1A. Oh, sorry. That's in 1A, 2 A and B. It's actually 1A3A and B, sorry. So that again was trying to reflect the committee's concerns that there could be the initial articulation of the clause perhaps was a little bit narrower than you wanted, and you wanted to have the capacity to pick out those people acting in a reckless manner.
Okay. In regards to, and I just asked members if they can have any particular questions in relation to the cyber flashing element. But just one question, Brian, in terms of where it says in 6A, does the reference to computer graphics in 6A cover the issue that has been referred to previously in the committee, the deep fakes and other such manufactured images?
Yes. Essentially, it's computer-generated images, which in fact have been separately called deep fakes or whatever, and they could either be wholly generated or they could be doctored pictures where you transpose a face or a body into a different person.
Any questions from members in relation to that? I'm just looking to see. Rachel?
Thank you, Chair, and thank you, Brian. Just in terms of the cyber flashing, I welcome the recklessness being included in the offence, but only tied to the sexual gratification motivation, which from reading the letter, it's reflecting on the Law Commission's views, and certainly happy to see the change to sending an image and the consequential amendments. But just in terms of the department's letter dated yesterday that was in our pack, it said the department proposes a departure from the wider UK approach as regards to sex offender notification and risk management, where Scotland has legislated for these factors to apply regardless of motivation. The department considers that applying such measures more widely risks over criminalisation. Would you be able to elaborate a wee bit more on the rationale for departing from the approach taken elsewhere, and what evidence are you using to inform this position within this amendment? Would you have, I suppose, any concerns that, say, a prolific offender, not motivated by sexual gratification, but say by some other intent to cause distress or alarm, would not then be subject to notification requirements or risk management?
Well, notification requirements relate to actually notification on the sex offenders register. Now, ultimately, that is the difference. The sex offenders register is there for a very specific purpose. It's about controlling potentially dangerous sex offenders. It's not there to actually register all manner of crime. And whereas we clearly see this as a serious offence, we'd be very concerned if we actually use that sex offenders register for other than actually sex offenders. Now, clearly, if someone's using a sexual image or to humiliate, whatever, it could be that it could be a sex offender as well. And certainly a pattern of that sort of behaviour may well raise questions. In that situation, it would be different. But certainly, that may well be, and again, in a court, the PPS would look carefully at the pattern of behaviour and see whether there was a sexual gratification element. And if it was, they would clearly be included. But if there was definitely not a sexual gratification element, then this might be about actually blackmail, it might be about vendetta, it might be about a range of other things, which clearly would be criminal offences, but certainly wouldn't be appropriate for the sex offenders register.
And just to add to that, the notification requirements and also the fact that it's been brought within scope of the sexual offences prevention order, for example, it's about managing risk going forward. So if that person, demonstrates a risk by doing this, then that risk has to be managed, and we don't believe it should be then aligned with someone who doesn't show any purpose of sexual gratification.
Okay, but and thank you for that. That was very helpful explanation, but it's still a divergence from the rest of GB.
It is, insofar as Scotland, we do believe the Law Commission did propose that it was aligned in a similar way to Scotland, that it should cover humiliation or distress, but that hasn't been completely firmed up yet. They're still pondering whether that's a requirement, and we haven't been able to get a firm response from the Ministry of Justice at the moment, but they are considering that particular area, so it's not completely firmed up.
Well, as any Law Commission report is a report until it's accepted and it's implemented. And certainly the Law Commission is still some distance away from producing its final report, and we have been consulting them. And on this and in some other areas, the jury's still out as to which way they jump. So ultimately, in fact, we feel that this actually is, on the sex offenders side, I think there's good reason to actually try to protect the sex offenders register from actually having it being used for other purposes. Ultimately, of course, if other parts of other jurisdictions take a different approach, we will keep an eye on that approach and see how it's working and see if there are any benefits or disbenefits. The fact that we're developing this law now, it's based on actually our best understanding of the situation. If the situation changes nationally, or more likely if we get better evidence from places which are trying a different approach, and that looks like it has an advantage, we could certainly follow suit. But certainly as it stands, we have a very clear policy about the sex offenders register, and ultimately to start to add in areas which are not sex offending to our register, which is explicitly focused on actually protecting people from such sex offending, I think would be problematic. So in fact, that's been our approach. And of course, Northern Ireland, it's not unusual for Northern Ireland to take a different approach from other jurisdictions. And indeed, actually, there's very often a difference between the Scots and the English and Welsh as well. So I'm not particularly embarrassed about us having a different approach. I think we have a rational approach, and it's one which is proportionate and in line with our policy about sex offending and sex offending registers.
No, thank you, Brian. It certainly wasn't to do with sort of, if there was any issue in divergent. It was just a rationale as to why. And the offences that we're talking about here in Clause 1 and cyber flashing, these are sexual offences. So, and maybe this is just a wider question, and forgive my lack of understanding, but if we're creating new sexual offences, they wouldn't automatically then be considered to be part of the sex offenders register.
Cyber flashing, it's certainly, clearly what we're saying in the legislation here and elsewhere is cyber flashing isn't just about sexual gratification. Sexual gratification is where sexual offending comes in. If the cyber flashing has been used for some other purpose, which could be blackmail, all sorts of things, it could be, the humiliation maybe because of that you're creeping into sort of revenge porn sort of territory as well. There may be a number of motivations behind this. But having said that, any time where they're using sexual images in this sort of way, I'm sure the police and the public prosecution service will look very carefully at the history to determine whether there is actually a sexual component. And it may well be, the person may argue that this was only to humiliate, yet in fact, you know, the evidence from their computer may identify a pattern which would suggest that that isn't the case. So in fact, you know, the fact that there is an option, a route to actually just look for humiliation, alarm or distress doesn't mean that if the person says, well, I committed this offence in innocence, I only wanted to annoy the person, that isn't necessarily going to be taken as gospel. The police and the PPS will look at the behaviour, and it may well be actually, you know, in many cases, it will be sexual gratification.
And just to add to that, that aligns with our voyeurism, the upskirting and downblousing, because there are the two motivations there as well, and we would only be you know, aligning the sex offender register with the sexual gratification. So it's the same approach.
Thank you, Chair.
Thank you, Rachel. Deputy Chair, Sinead.
Thank you, Chair. Yeah, listen, it's largely been answered. My concerns were along the same lines that Rachel has expressed there. And I was just a bit confused about this when I initially seen it, because it seems to me that essentially, you know, you've sent a sexually explicit image, you know, so the offence is the same regardless of motivation. So my concern just was that, is there a risk of maybe confusing the whole situation and maybe leading to some difficulties where maybe, you know, there is evidence that somebody has committed the offence under condition 2, but you know, they'll admit guilt to condition 1 to avoid going on the sex offenders register. So that was my main concern. You know, like essentially the image is still sexually explicit, regardless of motivation. So, you know, and if you're found guilty under condition 1, you'll have committed a sexual offence already, and you'll already be criminalised. So why should you not be subject to the same notification requirements as somebody who's committed the same offence but with a different sort of thought process?
I think in some ways it's very clear cut, and indeed when the PPS gave evidence to the committee, they did spend some time talking about the whole issue of intent, and intent is important because clearly on cyberflashing we know that you could find youngsters who actually send pictures, explicit pictures to another person in a train just to actually to annoy them, or in fact put them into an embarrassing situation. That isn't a sexual offence. It's a bloody stupid, excuse my French, it's a very stupid offence, but at the same time it isn't certainly going to be sexual. And we want to be careful that the sex offenders register should be used for catching people who are at risk of sex offending and managing them in an appropriate way. Picking up youngsters or people who foolishly do stupid things is not what the sex offenders register is for. And if we actually took it that way, we'd essentially over-criminalise. And I would say, you know, the sex offenders register is a very serious register, and being on it has serious implications for a person's future. So, in fact, I think, therefore, we need to operate in a balanced and proportionate way.
And just to add to that as well, your concerns about what is considered. Everything is considered in the round, and whatever the evidence points to will dictate how the PPS will prosecute. So if someone has clearly done it for sexual gratification, and the PPS are very clear that that's not a new thing that they're doing, that you know, it's an integral part of what they have to consider, then that will be obvious to them, and that they'll be able to line that accordingly.
Yeah, you know, it's just, you know, I'm wondering why there wasn't the same concerns about the sex offence register in other jurisdictions about maintaining the integrity of it. But my only concern was the department's rationale behind it. So I mean, if it's about maintaining the integrity of the sex offence register, which maybe is a bit of an oxymoron, but if that's the rationale, you know, I can accept that and I can understand that. So yeah, look, I'm happy with that, the information that we've got there, Chair.
It's both that and also to make sure we don't over-criminalise or over-criminalise often actually young or foolish people who actually think this is funny or are going for, they may be going to humiliate someone who's annoyed them or whatever. But the reality is they're just using, sadly, these sort of images are all too available, actually. available on the internet, and it takes a youngster now absolutely no effort whatsoever to find a seriously offensive image and post it. So, we're not in a situation it would have been, certainly in my day, where in fact this would have been enormously difficult to do. The reality is youngsters can pull images up instantly and can actually airdrop them to all the people around them just for an effect. And actually recognising it's going to cause alarm or distress, but being sort of essentially sort of indifferent to that. Now that is an offence, and I think it's absolutely right we prosecute them in that situation. But at the same time, it's maybe an offence of youth and stupidity, and certainly I'm not sure putting them on the sex offenders register will do the community any good, and it certainly won't do them or their families any good.
No, that's fair enough, Brian. I accept the rationale behind that.
Okay, thank you, Sinead. Any other questions on this part in relation to this cyber flashing amendment? Okay, members, if no one has in it, I just want to be sure that there's no one else. Okay. Are we then content for the committee to bring forward the amendment to provide for the offence of cyber flashing as outlined in the paper that's been brought before us? Content? Okay, I'll take silence as agreement. Clause 1, the upskirting and downblousing. Brian, do you want to make any further comment on that? You've really, I suppose, covered it in a sense.
I've covered it largely.
Yep.
Essentially, it's just what I explored with the committee last week, where there were a few options, and I think it was Peter Weir who actually sort of gave a nod to the particular approach we took, and there was no dissent from that. Yeah. So, in fact, that was on that basis we introduced. What is it? It's 1B. 1B really, which is actually the very much people operating in a reckless manner, and humiliation, alarm, or distress is actually caused. Okay.
Any comment? Any questions from members in relation to that? So, can I ask members, are we content for the committee to bring forward the amendment to clause 1? Rachel?
Sorry, Chair, I was trying to get my hand up quickly.
Okay.
Just in terms,
go ahead.
Sorry, just in terms with the recklessness there, just to confirm that's an additional limb of the upskirting and downblousing offences on both occasions?
Yes, it's additional. So you've still got the intent, but in addition to the intent, there is also the capacity for someone acting recklessly, knowing or being reckless of harm being caused and doing it anyway and causing harm. Yes, it's a further arm.
Okay, thank you. Any other questions, members? And if not, then we're content. Sinead Bradley, just apologies if I'm right. Okay, but you have been waving frantically, and I think it was to get my attention. Sorry, Sinead, go ahead.
Facility. I don't know what I'm using today, but it doesn't appear to be there. So apologies if I shout over. Just to say I really do appreciate this amendment. I think there was a lot of talk at committee about finding that pace about where the landing ground was in terms of making sure that recklessness, and that's the word we've landed on, is accounted for. And similarly, I just am satisfied that we've reached nearer to the place I think we wanted to be on this, and similar to the last one, so thank you.
No, okay. I think it's been a good outcome, because at the end of the day, clearly the committee has raised serious concerns. We've worked with you to actually find a workable solution, and we and our lawyers are content that this is eminently workable.
Okay, thank you. Okay, members, thank you for that. That brings us then to the need for the corrective amendment to clause 5. And obviously, Brian, maybe you could outline the issues raised in the two correspondence by the Minister during.
Right. Well, first of all, I apologise in the rush, bearing in mind I've had my team and our lawyers working all weekend on those clauses. We also actually were picking up a number of other amendments, most of them actually of a minor technical nature. And in this case, actually, perhaps our original letter, in our rush, to quote Wittgenstein, when he gave his thesis in to Bertrand Russell, he noted he didn't have time to write it shorter. And I think in the rush, we probably produced a longer version of the first letter than was necessary, and therefore perhaps confused the committee. So my apologies for that. My job is actually to advise and inform the committee, not to confuse you. I hope, though, my second letter, when we actually went, or the Dallow's second letter, which went through this in slightly less detail, what we just noted was the clause was in the wrong place. We did pick it up, and though in the flurry of work at the time of consideration, it perhaps wasn't actually flagged to the committee clerk or the bill clerk. And for that, that's unfortunate. But at the time, we saw this as a minor drafting amendment, not dissimilar from some of the other drafting amendments. Essentially, we saw what the bill's intent was, the committee's intent was, and we thought it's just a question of putting it somewhere else. So, in fact, we didn't have any great problems. But when we then went to the next stage of actually passing the link to our lawyers to work through all the areas, and that's when they rang the alarm bells. And in essence, in fact, what we were trying to do is put in an additional payment component into the 2008 sexual offending order, which is a very complex and very carefully balanced piece of legislation, which at the time I wasn't party to actually drafting it, but certainly at the time I know they were trying to balance a number of competing pressures and areas. The outcome was a very complex piece of legislation, and when our lawyers looked at it, they told us that if we put in the proposed amendment into that legislation, what it would do, it would clash with some other references to payment in the legislation, and it would also have a ripple effect affecting a number of specific offences which overlapped to some degree. So their advice was certainly it could be done, but at the same time, in fact, not done in a few days. This would require us to give them detailed policy advice on each of the areas to be affected. And realistically, that was going to be a significant bit of work in terms of instruction, and then they would then have to actually draft on top of that. So it was a very significant piece of work, and it was a piece of work we were not going to get done and dusted by next Wednesday. In fact, this was a work of probably some months, and we may well have to get more detail from the committee about the precise issues, areas it wanted to change, because our lawyers were saying, clearly you were trying to actually broaden the scope. The scope is already quite broad in the legislation. What they needed to know was precisely what additional areas were actually not covered and what additional elements you wanted to include, and how far you should go. So for all those reasons, we wrote the first letter, try to give you more detail, but my second letter, I hope, cut to the core and does explain precisely where we were. This is not us in any way. I told you at the outset that our view was the amendment wasn't necessary, but it's already covered. But the minister agreed, yes, we would support it. And it was on that basis we passed it to our lawyers to actually have it introduced. But having discovered this was going to cause a substantial amount of work, which is not possible in the time available, the minister wrote, and then the Dallow wrote, and then wrote again. And the minister is quite clear that this wasn't an expected outcome from this exercise. On the basis of the fact it is not doable in the time available, the minister certainly offered to instigate a review with the view of actually looking at this in much more detail and doing this in shorter time. I would also add, Mr. Chairman, that when I first spoke to the committee about abuse of trust several months ago, I told you at the time that our intention was to actually legislate in the next mandate, because this was a relatively complex area, and to get through and consult sufficiently widely would take time. So this is just one of those areas which may well have been picked up in that. But in essence, because we actually have speeded things up, it's meant perhaps we haven't gone through in as much detail as we would have done had we done a normal policy development process. So this maybe is a spin-off of that. But certainly the intention of the minister was to support the committee in introducing this amendment. But for technical legal reasons, it looks that in fact this isn't possible in the mandate. So that's the gist of what we were saying in the two letters, and I hope at least my second letter was intelligible, even to the first one perhaps was a little bit too legalistic.
I suppose for members to keep this all in some sense of context, because it can be very difficult to continue to link a number of pieces of correspondence. I suppose telling paragraph in the correspondence that we received this morning is that the current amendment, which we understand cannot be withdrawn, could be left stand, as it has no impact on the current or previous legislation. I suppose that goes to the nub of this. I suppose, as the chair of the committee and on behalf of the committee, I suppose the one concern that we have is really, given that when we were going through the various elements of the legislation previously, at no stage was ever any of this raised, and yet we had issues that were raised in regards to Clause 1, Clause 2 and Clause 3, which we subsequently worked with the Department in relation to getting, as we're doing now, getting an agreed position and a way. And I suppose we just we're concerned that, having done all of that in a logical, as much as we possibly could, based on the timeline of where we were going with this, then suddenly the Minister says something in the House that, I have to say, threw us, and we wondered, where has this come from? Why has this happened? And now we have a paragraph that just simply says, well, if it just stays in the piece of legislation, it has no impact on current or previous legislation. So it's a very long way to get to that point.
Well, I hope, like we explained in the second letter, there was no intent here. Our perception was, and we were coming up to consideration stage, that this was just another minor amendment. And actually, it was just, I think we realised on the day that, in fact, we hadn't communicated that to the committee. So that's perhaps why that appeared. But even actually after that, we took it away on the basis we were going to sort out the voyeurism and cyber flashing amendment, and we would pick this up as it would a number of the other minor adjustments needed to be made. We had not perceived, because we hadn't actually gone in detail with to this with our lawyers. We knew it was in the wrong place. We knew as it stood, it didn't actually have any impact. And our intent was actually to give you advice or produce an amendment which would actually deliver what the committee wanted. It's just once we got to that point, that's where we ran into difficulty. Now, in the absence of us producing an amendment, the existing amendment, which we understand can't be withdrawn because it's already been accepted by the Assembly, because it's not in the right place, it's in a descriptive paragraph, it'll have no effect, because in fact it doesn't require you to do anything, it just makes a statement. Now, to be honest, if you wanted to double fasten this, you could not commence it, but the reality is, even if you commenced it, it's not actually doing any harm. So to be honest, much as I've said to the committee a number of stages, our focus is on producing good law. I'm no more happy than you are about putting a bit of clause into a legislation which has no effect. But the reality is, in fact, there's one thing worse than putting a clause into a bill with no effect is putting the wrong clause into a bill that has effect. So, in fact, as it is, this actually at least ceases to be a problem if in fact we just leave it where it is. So it wouldn't be my preferred approach, but at the same time we have genuinely and honestly looked to see could we actually give effect to the committee's requirements. And there are formidable legal and policy problems. And on that basis, sadly, I think the best option is just to leave the amendment as it stands, since we can't move it, and then we can tidy it up through a miscellaneous provisions bill or something in due course. And the Minister has said, if the committee is strongly of the view this needs to be done, we will actually we'll instigate a review and actually look at how we can give effect to the committee's concerns early in the next mandate.
Any members, committee, any questions on that particular issue? I can't see any hands up. So, Rachel, thank you.
Yes, thank you, Chair. Thank you for your answer. Just to try and get my head around this, because it was my understanding the department's position was the amendment wasn't required, but then in the letter and with the committee report and then the letter dated today, it says the Minister is prepared to initiate a review to cover the committee's concerns. The review, just to clarify, Brian, would be about what we've been discussing as a committee with regard to payment, but the proposed legislation, is that to remove what's in the bill at the moment as a graded consideration stage, or to amend further legislation?
Our understanding is we can't remove the amendment as it stands, but it's actually been accepted into the bill. And if we don't amend it, then it stands as it is. Our review is actually to take a fresh look at this. Now, I have to say, Rachel, I have been straight to the committee throughout that our reading of this is not necessary. But at the same time, we would, the Minister is prepared for us to take a fresh look at this and again talk to the committee as well as now, if that's helpful. Just to establish whether, in fact, there is a meaningful way we can actually give substance to the committee's request. But I genuinely have concerns that this actually isn't required. But when you look at the legislation, it talks about payment, which includes goods and services, and it is actually broader than just finance at the moment. So in fact, I still am at a little bit of a loss to know actually what additional elements the committee is trying to put in. But I know that in your draft amendment, you didn't put in intangibles, which actually would have caused us some real problems of definition. So, I'm not absolutely sure it's required, but given that this has been clearly actually been an unfortunate circumstance, the Minister felt, if we should offer the committee the opportunity for us to actually look at this further, and can no doubt come back to the committee in the next mandate just with our findings.
Just add to that, we have to look at this in the context, and I thought the legal advice was saying, we have to look at this in the broader context of what law's already in. The 2008 order is a fresh piece of legislation in legislative terms, and there are wider protections for children in other law, such as Protection of Children Order, etc., and in the trafficking context. So child abuse, the intangible elements could well be caught in the non-prostitution, I don't like that word and we are changing that, those types of offences. So the other offences in the 2008 order, depending on the circumstances, may well be caught up and capture that. So there's no gap, is what we're trying to say. The legal advice was very clear on that. If there was something specific that the committee felt there was a gap in, we could look at that, but the current construct is proposed would cause ramifications for all the other elements because of the close-knitness of, if that's a word, of the 2008 order. But there's sufficient there, and the PPS had highlighted that as well, I know. When a case is considered, they're very complex cases, and that coercion could be caught under a non-prostitution type offence, but the intangible element could be part of that, and that would be considered in the round, and the person would be prosecuted under that offence. So what we're trying to say is we don't see a gap. The legal advice has pointed to that, but if the committee had somewhere where they felt there was a lacking, then certainly we could look at it. But it is a fresh piece of legislation. It's a complex piece. It's considered in the round of all the other child protection pieces of legislation we have. So whenever the 2008 order was constructed, we always look to what's already in place, what's existing, and if there is any legislative gap before you would duplicate anything, and that was considered, and it is fairly fresh. So with the legal advice pointing to that, and as Brian said, this was something that's come up of late when we delved down into the issue, and then it was discovered that, look, this really isn't needed, and these are the consequences if we do simply put that line in, because of the variation of the types of behaviours that are involved in these cases.
And strange enough, in a more philosophical line, the genesis of actually the clause which this relates to was us removing the word, the child prostitution, those sort of labels. And the reason we were doing that was because we don't consider children to be prostitutes. We consider them to be abused. Yep. So the payment thing is actually quite secondary. Regardless of whether they were paid or not, the reality was there's an offence about abuse of children. And that was that was actually the genesis of these changes. In some ways, I think the payment thing is actually a bit of a red herring, because ultimately what we're saying is that any child who is engaged in sex or controlled to get into a sexual situation is being abused. That's the real focus. If there's money exchanged hands, it goes to an adult, that's an issue. If it goes to the child, that's neither here nor there. The fact that they're getting some money for being abused doesn't make it any less child abuse. And to be honest, I actually think this is a little bit of a red herring. But that being said, the minister said we're happy to review this if the committee actually would find that helpful. And then certainly, we would certainly come back to committee on that in due course.
Well, worthy of note as well, the Articles 37 to 40, which deal with those types of transactional payment, drugs types of reward, they're very different from the other types of sexual abuse type offences in the order, where intangible may be caught, the love and affection and so forth. So we really don't think there is a gap, and that the definition of the financial reward, it's well interpreted by those prosecuting, by juries, by the judge in the interpretation of that, and the prosecution will be very, very clear on the elements that it needs to bring forward, and also sometimes it's not clear cut as to which offence it should fall under, depending on the circumstances of the case, and that's why we have this very complex piece of legislation that takes account of the wider legislative framework, if that's helpful.
Okay, thank you, Rachel. Sinead Bradley, are you okay? Yep. You're muted, Sinead.
I'm not sure. Can you hear me now, Chair?
Yep,
No?
I can hear you now.
Great.
Thank you.
Just say here that I really do hear what you're saying, that about you've not identified a gap. And just for clarity, in terms of the amendment is on the face of the bill, it's on the bill, it's there now, so the removal of it is not an option. The commencement piece, what are the options then? I hear you, Brian, saying that, if the committee was minded that the department would look at this, but what are you saying there? Are you talking about maybe adding a non-commencement?
No.
Could you just clarify? I didn't pick up on that properly.
Sorry, the amendment as it stands, because it's in the wrong place, has no effect. So it isn't about fixing it. In fact, if you were going to produce an amendment, to be honest, we would produce a fresh amendment in the next mandate if there's a gap, and actually it would be targeted at the right place and it would have effect. As is this, I understand this is complex legislation. It's not difficult to get. We worry about whether we've got everything in the right place, and that's why we actually spend so much time with our lawyers in producing legislation. This actually has been put, I think it's quite genuinely just been put there thinking that's the right place, but in fact, clearly it isn't. And to move it to the right place has as I've said already, a whole series of consequential issues which actually are problematic. As it stands, because it's in the wrong place, it has no effect. It's in the descriptive section, and it's just not slightly odd, but at the same time, it's not going to cause any damage. So ultimately, I suspect if we were, regardless of whether we actually produce a new clause somewhere else, sooner or later, if we got round to it, we would actually just remove it, which we could do as a consequence of some other bit of legislation, like a miscellaneous provisions bill. But the reality is, because it's doing no harm, we're actually relatively relaxed about that. Now, I have to say, if I could have actually, had we realised, if we knew then what we know now, we would have actually I would have been having this conversation with the committee before the consideration stage. And if that's the case, you would have removed it, and it wouldn't have had the problem. It's just because we actually hadn't appreciated its impact on the 2008 order that we thought well, this is a doable amendment, and we just had it grouped with a number of other minor technical amendments. And it's only when our lawyers looked at it, they rang alarm bells and sent me long and complicated explanations why we shouldn't do this. So at that point, we recognised that really this was not viable for us to actually fix this. So hence I've gone back to the committee.
Yeah.
Okay.
And it doesn't matter whether or not it's commenced. It doesn't have any effect if that's helpful.
Yeah, I think that is reassuring, because whilst some of us, I think, were approaching this with it wasn't going to have any unintended consequences or certainly do any harm, it is particularly reassuring, I suppose, to hear today that no gaps have been identified, so therefore we're not missing anything on this. So I appreciate those reassuring words. Thank you.
Thank you.
Okay, members, and I suppose just we're asking members to note the information that has been provided to us in relation to this. And really, Brian, to bring this to a conclusion, it might be helpful for members if you'd want to maybe give us some outline in relation or commentary on the technical amendments that the department is proposing, so that, and you've set them out in the correspondence to us, or they're corrective amendments. Sorry, they're not. They are technical, but they're corrective.
Yeah. Yes. Well, I'm not going to say very much because, as you've seen, they've been coming in during the course of the day.
Yeah.
And essentially, I know I've been talking to the first legislative draftsman and his team about these. But they will, well, as they're becoming available, we're letting the committee see them. If there are any particular issues or queries, that we can certainly, the OLC is able and willing to actually adjust them right up to the point when they're actually presented next Wednesday. So the committee will see them as they come along. Certainly, if there's any issues, certainly if the committee clerk or the bill clerk want to come and talk to me or to my team, we can clarify points. But as the Minister said, and as OLC are recognised, the aim is actually to give effect to the committee's wishes. So the amendments are mainly tidying up and putting a few phrases which are into the more traditional legislative terms. So nothing of material or damaging is being done to them. Essentially, it's mainly just about structuring them so structurally and organisationally they are consistent with good legislative practice. So I'm not expecting there to be any problems, but in fact, certainly, myself and my team are very happy to pick up to get phone calls if there are any issues you need to have clarified as they go past you.
Okay, thank you. Just check, although my screen has nope, we're back on again. Any questions or queries in relation to that? You can just happy to note. Okay, thank you. Was there somebody there wanted to make a comment? Because I can't see any. No, there's no hands up. Everybody. Sinead, Bradley, Evan. Yep. Okay, that's all right. Thank you. Okay, Brian. Thank you, and Lorraine. Thank you very much. And this may be the last time, Brian, that you're with us, as I understand you will retire.
Yes, I'm retired at the end of March, so in fact, and as I think this brings this bit of legislation through, I think all its committee stage actually is subject to obviously what you decide after we leave. So unless you actually suddenly have a strong desire to bring me back, this will be my last appearance at the committee. So I should just register that I've greatly appreciated the endeavours of the committee and the good humour which we've worked over, well, with this and previous committees, I have to say. And I've enjoyed the time, and I think together we actually, I think, have produced some very good legislation. And I think both the Minister and the committee have done an enormously good job in actually getting what I'm hopeful will be 5 bills through the Assembly in 2 years, which Christine would have told me at the beginning of this mandate was absolutely impossible. So I think we are both the Department and the committee have substantially overachieved this period and done so with not too many spats, a little bit of a wrinkle about that thing yesterday. But all in all, actually, I think it's been an enriching experience, so I'm very grateful.
Brian, I want on behalf of the committee to express our appreciation and thanks, my own personal appreciation for your candour and for your willingness to come to the committee and for all that you've done. And whatever the future holds for you, I trust that it will be happy, and I trust that you'll enjoy your retirement, and thank you for your public service in the time that you have given to the department. So thank you very much. Is there any other member? Is that sufficient? Or Sinead, Bradley?
Here. I just want to wish you very well, Brian. It's been great working with
you.
Rachel?
Yes, Chair, I think you so summed it up. Brian, thank you very much for all your service and for certainly being a great debating opponent on the committee in the last couple of years. I've thoroughly enjoyed it. And thank you very much.
You'll probably get a more civil servant next time.
Okay. Thank you. Right. And Lorraine, thank you as well. Thank you very much.
Thank you.
Okay, members, thank you. That brings us to agenda item 5. Oh yes, if you just give us a couple of minutes until we make preparation for our next officials who are coming. Okay. Okay, members, we'll turn now to item 5, which is the role of the Independent Monitoring Board in relation to the Northern Ireland Prison Service Care and Supervision Units, and it's an oral evidence session with the representatives of the IMB. Following the publication of the Criminal Justice Inspection Northern Ireland report on the review of the operation of care and supervision units in Northern Ireland Prison Service, the committee agreed to invite representatives of the Independent Monitoring Board to attend to discuss the role of the IMB, particularly in relation to the issues of the CSUs. And the Surgery report and associated papers are at pages 116 to 229 of the meeting pack. And can I welcome to the committee this afternoon Mr. Patsy Mcgonagall, the chairperson of the Independent Monitoring Board Council, and John Denver, the vice chairperson. And you're very welcome to the committee. Thank you for taking the time to come and to be with us this afternoon. And I will invite you to outline the role of the Independent Monitoring Board, in particular in relation to the CSUs, and then any comments that you may wish to make on the findings of the Surgery review. And obviously there is the report. We also had a joint session this afternoon with our colleagues in the Health Committee in relation to the RQIA report, and it made reference to the CSUs as well. So thank you for taking the time, and happy to hear your presentation.
Thank you very much. To introduce myself, my name is Patsy Mcgonagall. I am the chair of the Executive Council for the IMBs for Northern Ireland, which take in McGabry Prison, McGilligan Prison and Hydebank Wood. I oversee the 3 prisons at meetings with the IMB, and we would meet 5-6 times a year, and we take together all the things from each of the prisons, and we make reports then back to the Justice Minister.
Yeah, sure. The IMB are one of those people or groups that are very rarely heard of in relation to the Justice. I suspect very few maybe may have heard of the IMB here. So we are one of those things that sit under the radar, and we are appointed obviously by the Minister, and we are independent monitors of the prisons. People often say to me, do I go in and visit prisoners? And yes, I do, but more importantly, we visit prisons to make sure that the procedures that are there are adhered to, and that everybody is treated fairly and equally within the prisons. And that can be prisoners, obviously, in the foremost, but it can be prison officers at times. But our role is to make sure that we are assured and assuring the public and the Minister that that everything is fair and equitable within the prison service itself.
The role of the IMB is to, on each of the prisoners, they go in and basically inspect and see that everything has been done according to procedure. Rule 32s, which are like prison courts within the prison and things like that there, and they see that prisoners are being kept in a proper manner. We also take we ought to take the views of the prisoners. They would tell us various things that they're finding wrong or whatever. And in a lot of cases, we would go through the chain of command. We would go to that senior officer, and if we don't get sorted out, we go to the governor. We would meet the governor for a meeting to discuss that. We have a monthly meeting in McGarry, so yeah, and in Hydebank Wood and in McGilligan, where the IMB members come together and they crunch over everything that they've been involved in the month. And during that meeting, they also meet with the governor and put to the governor any complaints that they do have or things that they're feeling unhappy with. IMB members in Northern Ireland are very few and far between. Over the last 3 years, the number of IMB members has decreased rapidly. We feel the IMB is in crisis at the minute in the prisons because there are not enough people at it. We had been on to our secretariat for the last 3-4 years regarding that the numbers were very, very low and we couldn't look after the thing the way we should be doing. In our opinion, it wasn't being looked after properly. Most IMB members will be there'll be an IMB member, an IMB presence in the prison every day, and under a ruling by one of the justice, one of the judges in a case, the IMB are supposed to be in attendance to Rule 32s in any of the prison. For those who don't know, Rule 32 is when a prisoner is brought into the CSU, he's put on a Rule 34 and he's held for 48 hours. And at the end of the 48 hours, a judgment is made whether he's going to stay on in the CSU, and that then becomes a Rule 32 and a case conference is held, and we be at the case conferences, and we're there to oversee the case conferences are done, but we're also there to see the prisoners treated fairly.
I think one of the things that may be important to state that we are a statutory body. We are required by law to be there. We came from a board of visitors, we then morphed into the Independent Monitoring Board, and it is a statutory requirement that the IMB attend prisons. We are all, as Patsy said, all volunteers, all people who give up our time above and beyond the work that we do, and it's a very rewarding thing. Certainly from my point of view, I come from a fire service background, and I'm used to uniforms and I'm used to how things work along those lines, but it has been an eye-opener for me in terms of how prisons work and how prisons operate. So hopefully we're giving you an idea of what the IMB does.
Being an IMB member means that you're a master of all trades. You go under the prison and you could be asked anything under the sun. And what we think would be a silly question to a prisoner who's sitting in behind the door 7 days a week and 24 hours, that becomes a problem and it manifests. At times we are the people that would look after those problems and move them along and keep things under wraps where prisoners maybe become in some form or fashion troublesome to the prison officers that are in there.
Well, okay, thank you. And just so that you're set at ease, the bell that you hear is a division bell as the House is sitting, and so it's not a fire bell, and so you're to be at ease. And as I'm the only elected member who's in the chamber, my vote has been delegated, thankfully, so I don't have to run out every time that bell goes. So if we could just bear with us in relation to that as one of the vagrancies of having the House sitting on the same day as a committee meeting. First of all, thank you very much, and that is not an empty platitude and mere courtesy that I give. We genuinely appreciate and value the work of IMBs. However, I am concerned when I hear what Patsy has said in relation to the decline in number, and it's certainly something that we will, and I think I can be confident to say on behalf of the committee that we will be happy to raise with the Minister and the Department, because you can only do effectively the task that you've been given if you have the resource and the personnel to do it. So and we'll confirm that with members after this meeting in terms of our approach.
Can I just add just a wee caveat to that?
Yes.
They did run a recruitment campaign within the last 4 to 5 months that we really pushed to get done because we could see the problems down the line. And from the recruitment campaign, there's only 9 people who will be spread across the 3 prisons. This will take us to still well below what we're supposed to have. We're supposed to, in Maghaberry, we're supposed to have approximately 18, 19 members.
Right, okay.
An IMB member is supposed to be in a prison twice in a month, plus their meeting. The way it is with IMB members, every member is in maybe 8 or 9 times a month. And this is volunteers who are travelling maybe 60 or 70 miles at a time, and it's not really good enough, really.
And Patsy, on that issue, in terms of, so the complement of IMB members for the various prisons should be in the region of how many?
19 in Maghaberry. It's approximately 16 each in the other ones and around it. There isn't, it hasn't been a confirmed number, but over the years that's what they have told us they're expected. The last time they run the recruitment campaign, they looked for 19 members in Maghaberry.
Yeah, sure. It's difficult for us because we've been trying to sort of the IMB has sort of been one of those things that have morphed over the years, rather, and there has been very lovely people who have gone along and done very lovely things, but we need to put ourselves on a far more professional outlook in terms of statutory role and what we are required to do, because some of our members have ended up in court, have ended up talking in front of coroners and different people, and that's always a potential for us because of the role that we play. So we find it a little bit disconcerting. I certainly found it disconcerting that when you came in and we asked, as you have properly asked, how many people are on a board, the civil service cannot tell us that. There is no definite, this is how many people should be on a board. It's unbelievable that if you pick up the paper on a Sunday morning, you will have people asking for board members for different places, and they will indicate how many people are supposed to be on that board. But for us, it is literally look at your finger sticking in the air time, and that kind of sort of filters down to the fact then that we are sort of pushed to the side in terms of how we should have people involved in the IMB, and there has been that sort of, and I think maybe somebody will maybe be talking about this later. I know we came to talk about the CSU in particular, but it is a difficulty for us because if people, will tell us, the Minister has told us that we are very important people. I would only say to this that from my point of view, actions are going to be far louder than words on this one. I have lots of people telling me that we're very important, and I don't really particularly need anybody to tell me whether I'm important or not. But there's no actions on the ground that would say that the IMB are important to the Justice Department, even though we are somebody who inspects and are in prisons every single day. Where the Ginny and the Ombudsman and other people will come along and will do inspections on a 2-yearly or 3-yearly or when it is required. We are in there every day, so we are underutilised, I think, by the Minister in terms of giving a true reflection of what is happening in prisons. And in the case in point, in terms of the CSU, you could go back to 2016, where we were talking about problems in the CSU. And that voice was not heard by the Minister. Now, in fairness, the Minister was not in place. It was Permanent Secretary probably at that stage. But we have been persistently saying there is a problem there. And we hope that we have contributed to the fact that CGNI then have gone ahead and looked at the report, because I know that's something that obviously you're going to talk about. But we do feel, and as much as people tell us we are valued, I'm not sure we feel valued very much. We are the very poor relatives of some other departments of this, of custody visitors and stuff. We're way down the line there, and I'm not quite sure whether we should be or whether we deserve to be. I think we should be somewhere else on that list.
And I suppose that leads us on, and I'll then ask members to indicate if they have questions, and no doubt they will. Just a couple of things. One, in relation to the CSUs, I would take, John, what you just said, you would then conclude that you weren't surprised when you saw the content of the CGNI report in relation to CSUs.
No, I don't think any member of any of the IMB boards would be surprised at what's happened there. The CSUs, listen, it's a really difficult place. It is a very difficult place. And And the CSU is made up of people who are there because they have broken the rules in terms of discipline. Yeah. There are people there who are there for the safety and the safety of others. And then there are people there for their own safety. And in terms of those people who are required to be there because they've broken rules, we see them on a regular basis, okay, and it tends to be, some people have a regular route to the CSU. Yeah. But for those people who are in terms of the safety and the safety of others, where they may potentially be holding articles or items which could be detrimental to the prison, our concern has been for a period of time is that because they're being held for longer periods of time than they are required, so if someone is suspected of holding packages or drugs, some of that is based on history, some of that is based on hearsay, some of that is based on absolutely security intelligence. But in this modern day and age, there are better ways of doing that. We have been for the last 3 or 4 reports, Patsy, talking about X-ray machines which are used in other prisons throughout the UK in relation to different things, and that would minimise the amount of time that people potentially would be in there. And then, of course, the last category are those category of people who, unfortunately, because I'm not a medical expert, I can only simply tell you that those people are unwell. There are people there who are seriously unwell there. I'm not here to categorise what that would be, but those people who spend an inordinate amount of time in conditions and an environment which is not helping their position.
And I think the discussion today and on the back of the RQIA report, which was published in 2001, and we had a joint meeting today with the department from officials from health and also from the Northern Ireland Prison Service. And one of the recommendation 14, was around having an algorithm established which would clearly identify the needs of prisoners who are referred to the CSU, and that still is a long way of being implemented. So clearly, I suppose the other question that I would be keen to try and sort of tease, and I do take your concerns about how you're valued, and that will be noted very clearly, I think, by members of this committee, because I would like to think that we in the Justice Committee, and we were given a statutory role to scrutinise the operations of the department, need to have a clear understanding of where everybody plays their part in terms of. So you've mentioned custody officers, custody visitors. You've mentioned the role of yourselves, and then a variety of other reports. So whether it's the RQI report, whether it's a Sir report, or whatever. In all of those interactions that there has been, and there's a fair number of reports that have been over a period of time, have the authors, the people involved in the establishment of those reports, have they sat down with yourselves and asked you for your view, and then whenever the report was published, have you seen, and I'm not accusing the authors of the reports of being in any way disingenuous, but have you seen an accurate reflection which correlates with what it was you have said on the issue? Because you have clearly identified that you've been raising an issue of CSUs since 2016, but it took us till 2022 until we got a report that said that there was an issue. So, and I think that's probably a very broad generalisation, but do you think that is a fair comment, and have you been engaged in a way that you believe has been meaningful?
In 2016, we convened a meeting with the Minister, Sir John, I can't remember his second name, from MPM in England, Teresa Nixon at RQUA, and Tom McGonigal from the Ombudsman, and we met them and we put to them the problems that we were having in the CSU and the things we've seen. Basically, the mental state of a lot of prisoners in it. Prisoners being locked up for 23 and 24 hours a day. We went through the whole thing that what this report has highlighted. This is the same thing that has been going on in 2016. Every year from 2016 in our yearly report, we have put the same things on it. But there's a feeling from us that nobody looks at the report, or the Minister doesn't take on board what we're saying on it. Now, without trying to be in any way finger pointing at anybody, but over the years, I've been in the IMB now, going on to my 9th year. Being a member of the IMB, believe it or not, it will take you 4 or 5 years to find out what you're actually supposed to be doing, because there's no training for an IMB member.
That's what I was right.
There is no training for an IMB. You're just dropped in there, and it's training by Mary. The person in before you will train you. Maybe that person had it wrong, but anyway, it takes you 5 or 6 years to see what you're doing. And at that end, we have pointed out that we knew there's something badly wrong with the CSU. We have seen where beforehand there's been unannounced visits, and then people have been given off about the CSU and raised points of the CSU where it had to be looked at right away. And for the 6 months after that, or 6 months or 7 months, you will see a change in the CSU that constantly reverts back to the way it was before. And that's my problem. My worry with the recommendations made by Sijani people is that the recommendations will run on for 12 months, and then they'll start to slip back again. So they will, and there needs some sort of guidance on it. Yeah. We set up a thing with Sijani where we meet Sijani once every 3 months, and we go through them what we think are problems in the prison. And from the report that they have done, we've seen a lot of the things that we have said to them on the reports. We can see a lot of our essence on it. Now, we haven't been in any way been mentioned on here. We also, as they thanked other statutory bodies, so we're taking that we got the thanks for that on it. But we see a lot of IMB work in this here, so we do things that we've brought to them.
And what would be, and this is something that we need to pursue. But what I would ask is that you supply to the Justice Committee this one and any other subsequent one in the future a copy of your report, because they will be interested and ensure, and then that means that this committee will see it, and members will have an opportunity to question and make further investigations in relation to the issues that you raise. So, with those comments and those questions that I have, I'm going to ask then members. So, again, and apologies to both of you. I'm looking at 2 screens. One is all our papers, of which I can assure you there's a considerable number, and another because I'm the only one here who's a member of the committee, and I am trying desperately hard to keep them all, and they are all reasonably well behaved. But so I'm going to go to Sinead Bradley first, then I think Rachel, and then anybody else, please indicate. Okay, but Sinead Bradley first. Thank you.
Thank you, Chair. Can you hear me okay?
Yes, we can.
Great. Thanks to Patsy and John for your presentation, and I suppose I can reassure you that we do know what IMBs are, and I don't want to just throw out what might sound like more hollow words in terms of thanking you for what you do, but I genuinely do mean it, because I think it's very honourable what you do, and I also think it must be at times very, very difficult. And whilst I do know about your work and what you do, and I think your voice is a critically important one, because when you present information, I don't find myself having to sift through it for any agenda or what might be coming with it. It is about the welfare of those people that you're spending time with. But what I didn't know, and what you've enlightened me to today, was I wasn't aware just how casual the whole framework that is built around you is, and fragile, I have to say, from what you're communicating to us. So I think the Chair is right in terms of that is something that this committee or any future committee really needs to hone in on, because the value of your work needs to be represented in the serious nature of the structures built around you, to ensure, and I mean your comment there on training, Patsy, I mean that was so well made. That is an indication, if nothing else, that people being appointed to who knows what, and the possibility of facing, having to go through court proceedings at a later time, or coroners, they're not comfortable places to be for anybody. So in a voluntary role to present yourself, I think that whole piece of work needs to be, it sounds massive, but it sounds like something that has to happen. And heaven knows there's enough structures across the justice family that something shouldn't be. I'm not comfortable with any part of it sitting so casually and not being enshrined and well maintained, not just for the safeguarded prisoners, but for the people who are willing to come forward and do this role. I think there's a duty on the department to get this right, and I think I really genuinely appreciate you alerting us to that, certainly to me to that, and maybe other committee members were more up to speed with that, but I wasn't, and I think it's really important to know, and I don't think I could allow it to go unchallenged going forward now that it has been presented to committee. In terms of, while we do have you here, and I was pleased to hear, Patsy, you're talking about that you can see your contribution to the conversation on CSUs. You can see it in that report. And that satisfies me, I suppose, to an nth degree, while there's no credibility in terms of, not credibility, but there doesn't appear to be any recognition of yourselves contributing that voice. Nonetheless, it was heard. So it appears to me the channel of communication is open, but perhaps just not the recognition that should have been duly noted. And I know you don't sound like people who are precious about being there for the recognition. You appear to be genuinely there for all of the good reasons. But that said, I would be eager to hear from you both in terms of the CSUs. I note with time, you've changed the name of the CSU, the nature of what it's supposed to be, leaning more into the caring role that it's supposed to provide, and trying to change the whole image and philosophy around it. But ultimately, what never changed is it has, and it still is, to me, a prison within a prison. It is when there's a problem, no matter how that problem could be described, be it behavioural or be it something that it's a person that should never be there in the first place. They need to be in a medical environment as opposed to in the justice system. But I just wonder if you have noted any cultural change within the system that genuinely tries to make some type of distinction for when a prisoner is coming into CSU based on a medical need as opposed to a behavioural response. Is that detected in the way the person is treated during their time in CSU, or is there any distinction? Because it just seems to me all blurred into one big ball, and I really can't make that distinction. And I think it really does take being on the ground and witnessing it in action to make a fair reading of that. So I would appreciate both your views on that.
Thanks very much, Sinead. Right, we'll pick up on the prisoner. CSU is basically, as John explained there, there's three types of prisoners goes into CSU. They go in for discipline and good order. They go in for their own personal safety, and in a lot of cases that's people who have asked to go into the CSU. And they'll go in then, prisoners will come in to keep the prison safe. That could be anything. It could be some guy looking to create stab officers, or some guy that's got come in from a visit packed with drugs, and you can understand that. But there's also prisoners who go into the CSU, and John has alluded to this, that they're clearly not well. Yeah. Now, there is no distinction from that prisoner that goes into the CSU clearly not well as a prisoner that goes in packed with eyeballs. There is no distinction. There is no procedure in there for to separate that. In all fairness, the governor in Maghaberry Prison has indicated to us that he would prefer that Shimna House, which is would be used for in some form or fashion to separate that type of prisoner. They are aware. They do identify that there is a problem with that, but there's no rules, no regulations, no nothing. The only thing is that when we would go in and see a prisoner that we know clearly is not well, we would make our point to go to the South Eastern Trust and make them aware. Can we get somebody in from mental to diagnose some mental problems? We would highlight that. And in all fairness, I feel sympathy for the prison officers that are on the CSU regarding this, because they don't have that tool to work with either. They're there just to watch the people, just to make sure they're okay.
I think one of the things for myself, just back on what Patsy had said, is that the CSU in Maghaberry in particular, because obviously we're both from Maghaberry, is that the building is that was the area where everybody who gave you any sort of trouble went to. That's what it was. And initially that trouble was probably the breaking of rules, so therefore that was built around the breaking of the rules within the prison. But what has happened over the years is that sometimes now we've worked out that the breaking of the rules has been because people have been unwell, mentally unstable, they have behavioural issues, they may have mental health issues, and there are lots of causes for that breaking down of discipline within the prison. Now, there are people who willfully do things, I'm not trying to say there is not, but there are people, whatever. So would you find that there is no distinction because there is only one set of rules that covers all the people who go in there? You know, and to be fair to the staff, and Patsy and myself have on record spoken very highly of some of the staff who are in the CSU. They are faced with the difficulties of society concentrated very into a very small area. So all the things that we experience outside and all the things where we have the space in terms of mental health and people looking after you, and we can go for a walk or we can datter down the river or we can do it, none of those things are available to these people, so that cannot happen. So what you're doing now is concentrating the issues in that small area. So it's really difficult for the staff to do it, and they have done a tremendous job. Patsy and myself could have really good examples where staff have gone above and beyond to help people in there, you know. And listen, you know, there have been staff who were maybe not well suited for that position, but there are staff there, particularly at the moment, who are particularly well suited for doing that. However, if you go on to what is said in the report, there's no particular training given to those staff. It tends to be, they talk about jail craft, about sort of the experience of sort of working this up. And as much as jail craft and other things like that are all very good, that takes a period of time, and it's based on a sort of a testing the ground, see how it works, not based on the fact that here is good practice that we've taken from somewhere else, so we're going to give it to you. It speeds up the process of being able to look after a prisoner, especially those prisoners who are unwell or who have mental health issues. It speeds up the process of identifying quite quickly that they need to be somewhere else. In the recent past, we've had a number of prisoners who have transferred from Maghaberry to Shannon because it was clearly identified that there was mental health issues there. And that was, and way before they got there, Chair, was the staff on the ground had to deal with that. They were not mental health staff. They were just staff on the ground. So some of the expertise that they have gone up has been through, unfortunately, trial and error to try and get them there. But some of the compassion that is shown by some of the staff members is exceptional, to be fair.
We feel that there is definitely some form of training, that special training that officers who work in the CSU would need to identify problems in mental health. There is no training whatsoever for them at the minute, and we feel that on top of the South Eastern Trust mental health team that are on there, prison officers should be and have some form of training to identify someone who is in need of it. Unfortunately, in Northern Ireland, we don't recognise mental health the same as the way that England does. A personality disorder over here, the majority of cases that go into the CSU are referred to as personality disorders because they can't see any further on it. In England, they will identify this as a mental disorder. So we're stuck with this personality disorder that's not classified as a mental problem.
And I think too, Pat, not to cut across Sinead, but she did, and I think it's a very important question to ask. And if we could get some sense of it, she asked about have you seen a culture change? Because we're dealing with an organisation, so every organisation has either perceived or real a culture. And you mentioned, John, your previous experience in the fire service, and people have there's been a culture there, and so on, and we're all the same. Have you seen that culture change? Because you particularly, and I think, and it was reflected in the report, around some very good practice that has been identified, and that is. But because I will be interested just to hear that from your perspective, and I'm really pleased that we have ordered the way that this has happened, that you're here today, because next week we actually have the Chief Inspector of Prisons and the Prison Service, And I think that, and so a word of appreciation to our staff here, that was structured in this way, because this does give us a very different perspective and an independent perspective. So you're not coming in here with any need to say or an agenda. You're telling us as it is, and that is very, very much valued.
I think, Chair, in terms of the culture, I think they're probably, Patsy's much older than me, obviously he will know this more than I do. But in terms of experience, or Patsy,
more experience is
the fact that there probably undoubtedly was a time where the culture was that you locked up people who were disrupting the system, and therefore you put them behind and kept them away from everybody else to prevent the disruption of the system. But I think that culture has absolutely changed, and certainly, Patsy, I would be fair to say that certainly in the last 2 or 3 years, the speed of that change has been exceptional, to be fair. We have officers now who engage, and as I said before, Chair, above and beyond what is required of them, I suspect, in relation to their role. But I would say about that as well, is that is exhausting for those officers. It is an exhausting place, which seems like a strange statement. But when you're constantly being bombarded by noise, by shouting, by disruptive behaviour, it is an exhausting place. And I think one of the things that I think it was touched on in the report, those officers need to be looked after and maintained. Now, I don't want to give it. I'm not here, as you would expect. The prisoners are people that we're looking after, but it doesn't mean that we do not see and recognise what goes on within the prison itself, and that exhaustion, because the reason why we bring it up is that if we see officers who are exhausted, we see officers who will not do their job properly, we then see the outreach of that will be the treatment of prisoners. So there's a logical step for us to make sure that those people are actually at the top of their game, because if you have prison officers at the top of their game, you will have a culture and an environment there which actually helps those prisoners to get out of the CSU, which is ultimately what we're trying to do here. So it's that linkage between the prisoners and the prison officers, which even, I know it sounds a little bit strange, but that is actually quite important to make that linkage. And if we can do that, then that's a really important thing for us to do.
Just going back to what you said about the culture, as John alluded, I'm a lot older than John. So I've been on there now. I don't mean I've been in jail for 9 years. Don't pick that one. I've been in McGabbery 9 years. I was asked to stay on for another year because there were so few people. Myself and 2 other members have been asked to stay on another year. We applied to it. We told them we would stay on because there's so few people in the Imb. I forgot to add that in it. But the culture has changed considerably. 5, 6 years ago, when somebody went on the CSU, the line was, you're locked up, do your time. Sit there and behave yourself. That's the way the culture was. That has changed. It's changed with a lot of younger officers, and it's changed with some officers who were put on there. They look after that. Some older officers, and I don't want to mention names here, but I don't want to. But they have really put their stamp on it. So they have, but they still haven't got enough. They still haven't got enough. They need more training, basically. You know what I mean. The culture has changed quite a bit. There is care and concern now at the minute for individuals who are not well, which maybe mightn't have been there 5 or 6 years ago.
Ned?
Thank you. I think they're very comforting words and reassuring words to hear, and from a credible source such as yourselves. And I think your connection to the environment and all of the stakeholders and people being there ultimately do lead to the prisoners' welfare or not. So I think that was a very important point, well made. And just to thank you both, I think you've given us plenty here today. And absolutely, the Chair was right in terms of the correlation of this couldn't have been better. So thank you to the clerk.
Thank you. Rachel?
Thank you, Chair, and thank you, John and Patsy, for attending today. A lot of details and a lot of questions already answered there. I suppose I want to touch upon Patsy. I think you'd said there about having to be a master of all trades, and then you'd said something about training. Am I correct in what I heard there is that there's no training for IMB members?
No, there is no training for IMB members. You go through an interview process, so you do, and you go through you get through an interview and you're appointed basically, and you're sent on to partner somebody. You partner somebody in a prison basically, and that's the way the training is done. And that person that you partner may have done the exact same thing themselves. Now, and all credit to John, I have to say it. We have now 9 new recruits coming on, which is way below the amount of people that we need. But John has now done a training model, and it's just ironic. The training model of the 9 people goes live on Saturday and Sunday. We take that. Now that's our training model. It's not the Department of Justice training model. It was a model John, from his own work, put up here. So we're putting that training, and we're hoping that training module then be adopted by the Secretariat and the Department of Justice as the way forward for the trained IMB members, and it's a live document for stuff to be added to. So, and answering what you're saying, there is no training. Any training that we've had, we have to do it by experience. We're in there, and I'll thank John here publicly for has putting together the training package that we're going to be using from here on in. But once again, it'll need added to as well.
The thing about that, Rachel, is we haven't put the training package into any kind of action yet, so it could be a disaster. So I don't want too much praise in case I was horribly wrong. But my background was that I spent the last 15 years of my time in the fire service as a training officer, and to be honest with you, I was pretty horrified to come into an organisation as important as the IMB to find out that. Now, if you ask, Chair, I'm sure you will, when you ask about training, I guarantee you the civil service will tell you that there is training. But the training that is given is simply induction training that would be given to any member of staff coming in as a non-uniformed person into the prison service. If you talk specifically about IMB training, when I came in about 6 years ago, there was a 45-minute discussion with 2 IMB people, basically over a cup of tea, which really amounted to nothing, and didn't tell me anything about what the role I was about to do. In fairness, there has been a little bit of improvement because at least the last batch of people who came through, there was a guidance document put out for them, but it was basically somebody standing again from the civil service. I'm not maligning the civil service here, by the way, but it was just standing up and reading out stuff to them. There was no context of what was being read out. There was no understanding of what was being read out. There was no real involvement from an IMB perspective about how that would all work. And all of those things are completely alien to me as a training person. We were being told, well, the best training is to go into the prison and find out how it all works. And I'm going, well, I think you'll find it underpinning knowledge is the way to do it. And then by using your experience, you get the mixture of the both, and then you get the best people to do the job. So I was absolutely astounded by some of the things that we were coming across here. And I mean, and I'm astounded, but I wasn't surprised, to be honest with you, because, now, I have a platform and I will say it out loud, and in fairness, I have said it out loud to the Minister. We are an arm's length body, we're looked after by people who, to be honest with you, I've never seen in 6 years. Never seen them, never spoken to them with any kind of concern about what we did or how we did it or what we should be doing or whether we were performing well or bad or poorly. There was none of that went on. We have people who, up until probably recently, Patsy, we didn't even need to know the names of the people who were actually looking after us. And certainly, even though we forcibly in the last couple of years have stepped forward to say, well, listen, we need to be more involved, we need to have more involvement from the IMB and look more professional, and no disrespect to people who have been here before, yet we still struggle to get the names of those people, we still struggle to get meetings with those people, and you can tell from where I am. I'm not a shrinking violet here on the basis of stepping forward and saying stuff. My background is not one of those people. I'm not going to stand back and wait. So we need to get that done. It has been disappointing. Let's go with that. It's been disappointing that this hasn't been happening. And the IMB, for me, has been. I wasn't born to be in the IMB. I came along to try and help out and do what I wanted to do. But I sometimes shrug my head about some of where we are. I could honestly tell you, after 6 years in the IMB, I know about 70% of what I should know after 6 years. Now, what we're trying to do with the people who are coming in on Saturday and Sunday is to shorten that length of time they should have about 70% within 6 months of coming in, not 6 years, you know. And in fairness, I do think that the department who look after us have failed to do their role here and do their job. And I'm sure they will come out with some very clever words that will defend themselves. But I really think that they, you know, have left the IMB in a position where we're not sure what we were able to do or what we weren't able to do. We had people who are coming in who will talk to us about being visitors of prisoners. You know, as I said right at the start, Chair, I don't visit prisoners. There are other people who do that, chaplains, Samaritans, all those people. I visit the prison. And obviously, as part of that, I meet with prisoners. That's part and parcel of what I do. But there's a clear misunderstanding about what the IMB does and the statutory role of the IMB.
Unfortunately, that clear misunderstanding goes way up the chain. Our main thing that we constantly stand on is our independence. Our independence is sacrosanct. Everything that we do, we stay independent on it, and we have had issues where our independence has been challenged by the very body that we are supposed to work for, where we go to meetings and there's people from the prison service sitting at the meetings and we're supposed to discuss things that we are seeing wrong. You can't do that because it compromises your independence. And we went on National Preventive Mechanism people, we OPCAT, and asked them what do we do. They say extract yourself from that meeting. If you feel your independence has been compromised, go ahead and come out of that meeting. So that's where we are. It goes further up the chain. It even goes up to the Department of Health and Safety, the safety people, where we have had individuals from that who really didn't know us or didn't know what we'd done, and came along to our AGM and really left us feeling flat coming out of it, because there was a distinct hadn't a clue what we were doing, what we actually done in the prison. We have people who run our secretariat who have never been in over a prison door in their life. They haven't got a clue. But some of these people sat on the interview panels to bring in new people. How they can view a new person coming into a job if you've never been in a prison. So things like that are constantly happening all the time. As John has said to you, I am very deeply disappointed at some of the people that are supposed to be our framework and that we work within. And they be annoyed at us because we constantly ask questions and challenge why it's not happening.
Rachel?
Patsy, John, thank you very much. There's a lot in there which I will unpack before next week. I wanted to touch upon something, and this is something that I've raised with the Minister for the last couple of years on the use of CSUs, and I know that John and Patsy both set out, and obviously the Prison Service has done so, and the Minister's done so as well, on the use of CSUs, about why people would be in a CSU. And one of those reasons has been said to see if people are bringing in illegal substances and drugs into the prisons on their person, basically drug trafficking. Now, I've read your reports. I note from a previous report that 35% of those who were held in CSUs on suspicion of holding illegal substances were actually doing so. So that means 65% of people who were put into your didn't. Would you be able to explain a wee bit more about that? And I think probably know where your answer to this. Would you agree with me that there are other means the prison services could use to detect if someone is trafficking illegal substances or, say, items on their person? And what kind of conversations, if any, have you had with the department or indeed the prison service on perhaps body scanners?
I'll take some. In terms of Rachel, people bringing illegal substances into the prison, obviously, you know, if stuff comes into the prison, it can have a very detrimental effect on the prison. So I can absolutely agree with the fact that the prison service want to deter that at all costs. I absolutely get that. The problem is that when we looked a number of years ago, and because of the COVID crisis, that we've had to sort of drop that a little bit because it doesn't really reflect where we are. But certainly there was 35% was roughly where we were getting in terms of fines of stuff that was coming into the prison. Now, as you rightly point out, 65% then of people who were in the CSU were being held on either security information which was very poor, or other historical information where they had been involved before, and then because they had been involved before, they were now just held automatically within the CSU, and we were very critical of that. Patsy in particular will be able to tell you an example of that. And we were critical of those things. And the bottom line is that we have no interest at all in those kind of substances getting into the prison. That is absolutely not what we're about. But obviously, on the other side of that, we cannot have people who are held where they shouldn't be held within the CSU for long periods of time. And sometimes those long periods of time were 56 days, 96 days of being held and producing nothing. We won't go into the details of how they produce them, but it was all the details of producing. And we had asked the question, and certainly myself asked the question about body scanners, because if people come in and if they are given the option of saying that you can go through a body scanner here and we can check something, or you can tell us something, those people who refuse to go in, I have no issues with them being in the CSU, because there's something not right there for those people who refuse to use a body scanner. But when we've asked a number of occasions why body scanners have not been put into. If you look back at the reports, McGabry was quoted as one of the most dangerous prisons in the whole of Europe. Yet we couldn't provide the money or the facilities to have a scanner in there. Now, we have asked that question of the minister, and there have been various answers. Let's go with that. There have been various answers and reasons why this hasn't happened. The IMB would be of the opinion that that is a vitally important thing for the health and safety of prisoners, of prison staff, of everyone else in the prison. And we struggle to understand why that has not been pushed forward. We really do. And I said so in last year's report. Rachel, you read that. I was very critical of that. Now, it's not our job in particular to make recommendations, and I understand that. But, it's one of those things where if we're looking after the safety of everybody, not only the prisoners but the prison staff, then the reduction of drugs in the prison is something it should be done. And if we can do it by the technology that we have, that rather than the more agricultural way that we do it maybe at the minute, that would be a good step forward.
Thank you, John. Sorry, Patsy, did you want to come in there? Apologies.
Sorry. Just can I add to that? Some of the prisoners that they're talking about that didn't have anything on them spent 28 days in solitary confinement, basically. That's what they spent, and didn't have anything at all on them. So we constantly object to that 28 days. There became a time in there when somebody come in that they thought for 1 second they had some on, they were automatically at 28 days. Something we protested about quite strongly about it. And sometimes the 28 days would have came from a security thing where we didn't have any access to the note that came into the security. They would just tell us it's a security issue. And we felt that was all wrong, that there should be some other method. And really and truly, in today's modern world, if the prison service was aligned to working in a factory or whatever, the resources that are put to that 70-odd% of people that had nothing on is a colossal amount of money, when the same resource could be used then for the rest of the people in there. So if you take the value of the hours that are spent watching people who have nothing on and put that to a body scanner, I dare say it'll work itself out eventually.
Thanks, Patsy. There's no need you don't need to convince me on the merit of it. And I suppose just getting onto the Psni report, which I'm very glad to see has been published. I know that it was with the department back last year, and then we received it a couple of weeks ago, October last year, and there was a statement made by the Minister in the House then to the Assembly. The IMB was mentioned in that report with Psni, and I suppose would you be able to outline your involvement in that report and the recommendations? And I would also like to see a secure mental health ward available for those who need it. We have just come out of a joint committee meeting with Health, as the chair has previously stated, and that was certainly something I asked the Department of Health during that meeting. I just wonder if you have any feelings on that as IMB members.
I think from the point of view of Jackie Durkin involved the IMB quite early on in terms of asking us questions and getting our feelings. The two inspectors talked to us quite extensively to all three prisons. We give our views, and to be fair, they took our views on board really well, and maybe went looking in places where they may not have looked before. So that was very good from our point of view. In terms of the recommendations, you know, we agree obviously with what the recommendations are there in terms of what they want to do, but we understand as well, you know, there's not a pot of money here that can do everything. You know, I would absolutely agree with you, Rachel, you know, in terms of the mental health of some of the people who are in the CSU in particular. That is not the environment for them. It really isn't, you know, and you know, I know there is Shannon, and this is where it falls sometimes between a rock and a hard place, because to be fair to the prison service, it's, you know, they're just dealing with what they have to deal with. The South Eastern Trust are there to deal with the mental health of people, and therefore what happens is that you have two bodies. I'm not saying fighting over who owns or who has jurisdiction over an individual, but sometimes if that happens, you then get a void in between it, and the person that is missed in between will be the prisoner, and then by default the person that's missed is the prisoner, and then the prison officers who are dealing with the prisoner. And we talked, you know, to the South Eastern Trust, and they had a saying which we quite liked. You know, they said to us that sometimes people get numb about what's happening. People just get numb. It's just accept it. That's where we are. There's somebody in there. Who is it? John Denver. How long has he been there for? 60 days, 40 days. Well, there you go. Just move on. Okay? And that's that statement that they made about being numb about this. It's actually what the IMB is about. We are the annoying children in the back of the car who say, "Are we there yet? Have you done something? Can you do something?" And we are, and we accept that. On a good day, we're annoying. On other days, we're even worse than that. You know, so we accept that that's where we need to be. And for me personally, I'm sure from Patsy and the other members of the boards, I have no problems about that, because ultimately we're trying to make things better for everybody. Why people get into prison is not my concern. The journey that took them there is not my concern. My concern is when they're in prison, that they're treated and pointed in the right direction of either trying to re-establish them into society, or if they're going to spend a longer period in prison, that they are the least disruptive people within the prison, because prison officers, that's the place of work. People do not want to go to places of work to be, you know, involved in difficult situations on every single day, you know. So from our point of view, I think the CGNA report sort of echoes what we've been saying for a period of time, Rachel.
Totally agree that it echoes what we've been saying for a period of time, but to go back on the point that John made there, the ownership of a prisoner basically between the prison service and the South Eastern Trust, there are times when that prisoner will fall through that grate and he gets nothing out of it. A prisoner may be in there and he suffers from mental problems, but he becomes violent. So the prison service have to control his violence. So therefore the health people won't go under him because he's violent. But because he has mental health problems, again, he can't get treated. So it becomes a vicious circle, and that prisoner falls through it all the time, doesn't get any treatment. And that happens on a regular basis, so it does. It happens on a regular basis as well, too, where guys go into the CSU and they're locked up for 28 days and they have no meaningful interaction. And they have, it basically gives them mental problems at a later date, so it does. So we can see guys that come in there who are good enough prisoners, but as because of 28 days or maybe a number of 28 days in the CSU, you can see them gradually getting worse and worse on their mental health.
Patsy, John, thank you very much. I could probably take over this entire meeting talking to you and asking you questions, but I'm mindful of the time I've taken and the time that you've taken answering my questions. And just thank you very much for all of your work within our prison system and for the work that you do and talking to prisoners. I appreciate that this is probably an extremely difficult role that you have. So thank you very much and wish you all the best with your training as well.
Thank you.
Thank you. Thank you, Rachel. Any other members? I don't see any other hands that have indicated. Can I just maybe conclude by asking one other, and I think like Rachel, there's a number of other things that we would, so if this mandate had been any longer, I can assure you, you would have been back. But we will, after this meeting, forward some questions to the department on your behalf, and we will be happy to share them with you then after we've received answers, whatever they will be. Do you see a difference? And when you look through the Sir Jenny report, obviously the compare and contrast McGabbery and McGilligan. Now, obviously McGilligan has a different type. Maybe this is not it's a clumsy way of putting it. Not being disrespectful to the prisoners, but they're serving out the last number of years of their sentence. So therefore, that doesn't rule out that they'll not end up in a CSU. And McGabbery is, you know, a very challenging environment because of its history and do you see? Are you able to draw a distinction between what goes on in McGilligan and what goes on in McGabbery? And does it and is it the case? There's a point that Patsy made about the fact that there are prisoners who have health issues. That's abundantly clear. But do you see them a prisoner who has those health issues or those mental health issues reacting differently in a McGilligan setting as opposed to a McGabbery setting?
The first thing that's really interesting is that the CSU and McGabbery will have an average of 16 or 18 people in it at a time. McGilligan may have 2 people in the CSU in a month.
Yeah.
So it's completely different. Hydebank may be the same too. There may be a couple in the CSU, but
I think that Chair, the reason for that, there is a reason for that, because McGabbery is the prison that everyone goes to first.
Yes.
Okay, so that is a committal prison.
Yeah.
So people come from courts to McGabbery. So if they are there and that is their first point of contact with prison, then that's where they will come through. Their behaviour will be there right at the start. Now, those people who are then moved potentially from McGabbery up to McGilligan, they've already been sort of settled prisoners before they go up there. Yeah. So their behaviour is usually pretty good because they have an understanding of it. But if you have prisoners who come directly from courts to McGabbery, they are the most volatile prisoners. So they will be in there, and I don't like. I was going to say the word conditioned there, but it's not conditioned. But they're nearly used to the prison regime, and those who are settled prisoners are then transferred to McGilligan. So that means that, you know, it's not that they don't have their problems, and you can have individuals who do things, but the people who are the most troublesome or the most troubled people or unwell people tend to stay in McGabbery because they are volatile that they won't go up. So therefore, that's why we will have 16 to 18 people in our CSU, or the CSU, not our CSU, the CSU in McGabbery, as opposed to what will be in McGilligan, because it's a different type of thing going on here. Yeah. This is a melting pot. McGabbery is a melting pot of people, whereas what you have is a more refined prisoner who goes up there.
And I think that is an explanation in terms of context. And I think that is what you would or you should expect in terms of the nature of those two. I suppose the other part to bring this to a conclusion, and I'm interested because I visited McGilligan and I've been in McGabbery. I've been in the new prison in McGabbery, and I just wonder, has that new facility made any contribution? And I take the point that Patsy's making in relation to you could have 16 prisoners in the CSU and so on in McGabbery as opposed to 2 in McGilligan. But has the new provision helped in any way to reduce the numbers of prisoners who end up in CSU in McGabbery?
It's really too early to tell, so it is. Right. We still get a lot of guys on the CSU out of Davis House, out of the new place.
Yes.
So it's hard to tell. We don't have a number on that. It's maybe something we should take a wee look at to see if there are some. I will put something together. We'll put something together on it and see what the figures comes out as. But
I think that the difficulty is because prisoners are coming in because of the COVID thing. They're being isolated quite early in conditions which aren't good. Davis House, in terms of a facility which is a better environment there's no doubt it's a better environment for prisoners. And there will be all of that, but there are just, as you would know, Chair, there are prisoners who it wouldn't matter where you would put those prisoners. Unfortunately, they have a tendency to find themselves in trouble for whatever reason, But certainly there is a better environment in Davis House. There's absolutely no doubt about that, and it doesn't create that sort of. It doesn't create that environment where people believe they're on top of each other, and that creates a problem in itself, But certainly the facility in Davis is excellent, but as Patsy said, I think it's probably too early to say if that's made a huge difference.
Well, I think this has been extremely useful, and apologies that we haven't been able to have you sooner. And I think it was Rachel, and just appreciation to Rachel who had been asking for you to come. So it's always good when members see the fruit of their work, and we are able to get to that point. But thank you so much. We will have a discussion after, not because we're hiding anything from, because we're in public anyway. You'll be able to look at it again. But I think there's a number of things that we'll want to ask from the department in relation to the operation, the training, all of that. And be assured, I think you have given this committee a lot to think about, and certainly many questions ahead of what we will have next week when we have the Chief Inspector and also the Prison Service here. So to Patsy, to John, thank you very much for your time.
Thanks very much for having us.
Thank you for having us.
Thank you.
Thank you. Members, I suppose what I would certainly want a number of things. One, I would love a breakdown from the department of so many people in the Secretariat and their roles and responsibilities. There's the issue as well as to the way in which what is or what is not the training that's provided to members of the IMB, how they intend to attract, and Patsy had been mentioned to the fact that at a recent recruitment that there was a very low uptake. I suppose, is there any other specific things? What I would be keen to do is, rather than ask the staff and the staff here to do something in a rushed way, that we try and put together a number of, so members can put in what they believe should be included, so that we have as comprehensive letter going to the department, because I think those two gentlemen have given us a lot of information today, which does raise concerns in relation to a number of issues for just the sheer practicalities of what's going on in our prisons. Any comment? Rachel?
Thanks, Chair. No real comment. I think that's sensible if anybody's got specific questions and so on, but there was a lot there. Yep. There's a lot to cover. Certainly, I think even just for a suggestion for whoever the next Justice Committee is, that whenever we're having I know at the start of the committee, certainly 2 years ago, we got an overview of the different services underneath the department and the arm's length bodies. We had the courts in and we had the police in and so on. But whenever we're discussing the prison service, that perhaps the IMB should be brought in, or as part of that kind of discussion, just for new members going forward. But certainly the recruitment and training, I'd asked a number of questions on the recruitment and training, but it does concern me greatly that there would be no official training in place, especially, and perhaps that's just the model it's been. Perhaps what they're doing at the moment is the best way, but just to leave people who are volunteers at the end of the day. Yep. So we have to recognise the massive contribution that volunteers have. and the support to do their job. But also, obviously, and I continue to bring this up again, which would be on an update on body scanners, because I think this is. I'm going to continue talking about this. It's not something, that talk about lightly. I think we should not be having any situation where somebody is put into a CSU for a month to see whether or not they might or may not have anything on their person. Yeah. It doesn't sit well with me at all.
Yep, and too, Rachel, this has been an issue that has been, if I am right, has been around since 2014, and we're now in 2022. So I think we should keep it. And there is the other issue too, that there's an end of mandate report. So we'll include the whole issue of the IMBs in that. And the other thing that I think we should do is to ask the department as to what it does with the reports that have been previously. So if you read through, I was just scrolling through the one in relation to McGabry in 2019. I think it talks about disappointed and it uses all that phraseology. But I just wonder what was the department's response to the IMB report or reports. So there's been a number of them. So I think we should include that as well, so that we're trying to be as comprehensive as we possibly can. I have to say that's one of the most valuable presentations that we have had for some time on a very practical basis. And I think the other thing is independent is a word that is important in terms of their role and their function. So, okay, anybody else? Just so that we've Sinead?
Can you hear me okay,
yes,
Chair?
Yes, we can hear you, yes, yep.
Yeah, Chair, if I could just add to that, I think you're right. I think it was a most informative presentation, and it was a very honest presentation. Yes. Yep. And I think a lot of the there's a whole lot has been presented to us here, and I would go so far as back as the point when John had said that he's not even clear about what the ratio or the number of members that should be on each board is. So what is the framework? Where is this? Is it somewhere in the department that there should be a particular number? Is it a ratio that runs in correlation with the number of prisoners at any one time? And if there's such a shortage, which there appears to be, why is recruitment not an open rolling type of recruitment? Why does it open and close? Yeah. Because I can imagine the goodwill of volunteers being overstretched is not a good way of retaining those volunteers.
Well,
so
I suspect that the very fact that we have had the response that we've had in relation to the recent recruitment is an indication of the fact that they are volunteers and they have been having challenges, and maybe we do need to ask the department to seriously look at the way in which they are remunerated for the particular role that they carry out.
Absolutely, but Chair, if we could just ask specifically about that framework. What is there? What is it that the department there's a duty to these volunteers, and I'm not sure, even though that, albeit that they're an independent body, yes, but there must be a duty that there should be minimum numbers and reporting mechanisms, and their welfare and safeguarding are being tended to. And I didn't hear anything that reassured me in that today. So I'd appreciate if we could put those points to the department. Thank you.
Okay, thank you, members, for that. And that brings that item to a conclusion. We then move on to agenda item 6, which is the SL1, the Police Pensions Amendment Regulations Northern Ireland 2022, and it's an oral evidence session with departmental officials. They are attending via Starleaf to outline the proposals for a statutory rule to amend the 2015 Police Pensions Regulation to ensure the prospective parts of the McLeod judgment remedy can be implemented. The relevant papers are at pages 230 to 265 of today's meeting pack. And can I welcome via Starleaf to the meeting this afternoon Lynn Curran, Head of Police Powers and Human Resources Policy Branch, and Antonia Hoskins, the Pensions Policy, Police Powers and Human Resources Policy Branch. That took me a minute or two to say all of that. And you're very welcome to the meeting this afternoon. I would love to say that this is going to be not because of your lack of ability to be able to convey this to us, but as informative as the previous presentation. But I do appreciate how challenging and difficult this is for probably yourselves as much, or maybe even more for us, because it is a complex issue and has many, many moving parts. And so I really do appreciate the information that you've given us to date. You're very welcome, and I'll ask Lynn to make her presentation and her comments, and then members, if you have any questions, then we will proceed. But Lynn, thank you very much.
Thanks very much, Chair. We'll try and make it as short, as sweet as possible, and we'll try and make it as clear for you as possible. We struggle with it ourselves sometimes too. So look, thank you for letting us come here today. We have provided written briefings to you in the past, in June and November of last year, so we'll welcome the opportunity to brief members today. By way of a short background, in 2011, the Government accepted the recommendation of Lord Hutton's report on public service pension reform, and in March 2012, the Executive agreed to mirror this reform and not to adopt a different approach for Northern Ireland schemes. In 2015, across the United Kingdom, the career average reforms were applied to all public service pension schemes, including the police scheme. However, following consultation with staff associations, transitional protection arrangements were agreed to allow certain older members to remain in their pre-2015 legacy pension schemes, while other members were moved into the reform scheme on the 1st of April 2015. However, in 2018, the Department of Finance, who is responsible for public service pensions policy in Northern Ireland, advised officials of a legal ruling in England and Wales, and you've already alluded to this being the McLeod judgment. This ruling found that the transitional protection arrangements gave rise to unlawful age discrimination against younger members in the judicial pension scheme and therefore must be remedied. This has become known as the McLeod remedy. In 2019, the Westminster Government accepted the public service pension schemes with comparable transitional arrangements would also require a similar solution. As a consequence of the McLeod ruling, the Department of Finance decided on the 25th of February 2021 that in order to remove this unlawful discrimination, public service pension schemes in Northern Ireland should apply a remedy in two phases. So phase one is known as the prospective remedy. This closes the legacy schemes on the 31st of March 2022 and transfers all active members into the 2015 scheme on the 1st of April 2022 to ensure the removal of the unlawful difference of treatment on the grounds of age. It is this part of the remedy which is being addressed by the proposed amendment to the Police Pension Scheme regulations, which is before the committee today. Phase two is known as the retrospective remedy. This will allow eligible members a choice as to whether they accrue benefits in the 2015 scheme or legacy scheme between the 1st of April 2015 and the 31st of March 2022, which is known as the remedy period. Further legislation to implement Phase 2 by the 1st of October 2023 will be brought before the Justice Committee in due course. So in line with Phase 1, the Department of Justice has a statutory responsibility to bring forward the amendment to the Police Pension Scheme Regulations Northern Ireland 2015 in order to ensure that the prospective part of the McLeod remedy is in place by the 1st of April 2022. The proposed regulations also contain minor technical amendments to improve the operation of the 2015 scheme for the benefit of members. Excuse me. The Public Service Pension and Judicial Offices Bill, which is currently passing through the UK Parliament, provides the powers to implement the McLeod remedy. On the 1st of November 2021, the Northern Ireland Assembly approved a legislative consent motion for this bill to be extended to devolve public service schemes, including the police scheme, which are aligned with those for public service pensions in Great Britain. The Government Actuary has estimated the cost for the police scheme in Northern Ireland to be around £140 million. DOF has advised that as McLeod costs are classified as a member liability, they must be accounted for as such in the valuation process. However, the legislative consent motion for devolved schemes, which was agreed on the 11th of November 2021 by the Assembly, will see no negative effects for contribution rates or benefit levels as a consequence of any cost cap breaches arising from the inclusion of McLeod remedy liabilities as a member cost in the 2016 valuations. DOF has also advised that the second legislative consent motion for the Public Service Pension and Judicial Offices Bill, agreed on the 31st of January 2022, will ensure that in future Scheme valuations will assess costs in the reform schemes only, and the cost of legacy schemes will pass to the Exchequer. This should promote stability in the cost cap mechanism for the future and protect members and employers from unseen cost changes. However, it should also be noted that the Department of Finance has advised that failure to implement the prospective regulations and remove the age discrimination by the 1st of April 2022 is estimated to cost the Department of Justice £20 million per year for each year that it's delayed. Any such delay could also risk legal challenge. So in conclusion, Chair, I hope that members will be assured that the proposed amendments are consistent with the Executive's will to address the issue of discrimination as it applies to affected public service pension schemes across the United Kingdom. Thank you for the opportunity of coming here today. Myself and Antonia are now happy to take your questions if there are any.
Yeah, thanks. Then I suppose maybe the first question is this: what do you think will happen if the public service pensions and the Judicial Officers Bill don't receive royal assent before the Assembly is dissolved?
That's a question for the Department of Finance, I'm afraid, as they're in the lead of the bill.
Right. Okay. Right. Okay. That was. We will forward that to them. And are there any significant changes to the 2015 scheme?
No.
No.
Apart from the fact that the transitional protections are being removed and that people are being moved into the active scheme, into the 2015 scheme from legacy schemes.
And there's talk about these technical amendments that are being made, and what are they in relation to this? And will the operation of the 2015 scheme then be improved?
It's sort of things like where when we made the regulations in 2015, we have misquoted a paragraph or a reference or a title has something left in. One of the ones was it had part-time and the part-time shouldn't have been in the reference. It's those sort of technical amendments.
If I give you an example of that, Chair, one of them is the amendments is the automatic death gratuities for active members, and that's ensuring that ill health retirements currently in progress are treated no less favourably. Right.
Okay. And I suppose the last question I have in relation to this, obviously, and I assume that this is the case, but just sort of for clarity, has there been engagement with the PSNI on the potential cost implications of the changes, and has the PSNI indicated that it will need to bid for the necessary resources in the year? Because obviously there is a considerable bill comes as a result of this piece of legislation.
The resources have been applied for by the PSNI. I have to say I don't directly deal with the finance end of that, but I do know that the resources have been bid for, and they are fully aware of the MacLeod resources and staffing that they need, and they have them in place to do so.
And Antonia, is so that, because sometimes we can get caught in a situation where it is whose responsibility it is to determine what it is, the resource that they need to bid for, because we've had comment from the department in the past in regards to the PSNI that they didn't bid for a particular piece of money, so therefore it wasn't really it's not about apportioning blame, but it wasn't the fault of the department that was the case. So is there a working relationship between the department and the PSNI, the senior management team of the PSNI, to ensure that everybody knows who needs to do what to ensure that the legal requirements of this piece of legislation is actually delivered? Because we are talking about a major change given all that happened as a fallout of the MacLeod judgment.
Yes, both the board and the PSNI have actually updated this a meeting at grade 5 level right across all the public sector schemes, and both the PSNI and the board have fed into their resource requirements, and they have also way back in April or May of last year and certainly they have bid and they have the resourcing for an IT system to be able to actually be able to deliver the McLeod in the time that they have. I know the board have a calculator for the people in McLeod, and that's due to come online hopefully in June or July. It may need a bit of testing to go ahead. The government actuary is still fine-tuning it, but certainly the PSNI and the admin side know exactly who they need, what resources they have, and I think I can't be fully confirmed because I don't know, because I'm not an HR person in the PSNI, but I am aware that they either have recruited or are in the process of recruiting. I think possibly they have recruited a team to be able to deal with McLeod.
Okay.
I think, Chair, I think it's also fair to say that the department has been liaising very, very closely with the Policing Board and the PSNI on all of these, and certainly looking forward to the next set of regulations that will have to go through for October next year. We intend to set up a very, very close working relationship with them in relation to that.
Yeah, and apologies, I should have declared an interest as a former member of the Policing Board. I didn't sit on, thankfully I didn't sit on the Resources Committee, but I was a former member of the Policing Board. Just one other query before I go to members. Antoinette, you did say that the issue of the service pension and the Judicial Officers Bill was an issue for the Department of Finance. What happens with this SR if we don't have royal assent?
If we don't have royal assent by the closure of the Assembly, then obviously the bill won't go through, but we won't be alone, if you want to put it in that term. None of the bills can be made, I think, unless somebody goes in the Department of Finance and seeks legal advice as to whether we can make it. Okay. But as far as I'm aware, once the 25th comes, we can't lay the regulations after that date.
Okay. Okay.
And I think you probably recall, Chair, from my opening statement there that there is the huge financial penalty to the Department of Justice of around 20 million per year if this doesn't go through. So we really are, I don't want to say we're keeping our fingers crossed. We're confident that it will attain royal assent, but who knows?
Okay. Yeah. Okay. Okay. Sinead Bradley.
Yes, Chair. Just it's a question. It may not be appropriate to ask you, but I'll try it anyway because it's something that was in the back of my mind on this. I appreciate this has come out of the McLeod judgment, and you talk about legacy terms and also the calculator coming online. And I just wondered, because it is highly complex and there's all those underlying things such as you refer to, in the event of death and the transition piece and that, is there any likelihood, or have the department scoped out whether there's any likelihood of further legal challenge when this settles? I don't know if this is a finished piece or if it's something that could be. Is there any undercurrent there you think when a person starts to realise the reality of this isn't maybe what they thought, or they feel somehow disadvantaged by it? Is there any possibility of that?
We already have an industrial tribunal case for 3,700 officers, or in fact slightly more, who are looking for injury to feelings for the fact of the move. The bill does allow for some elements of compensation in terms of, but it really is on a one-to-one basis in terms of people's decisions as to whether they move or whether they didn't move into the 2015 scheme. There are a lot of rumblings across the water, across all of the schemes for various things. Here we have nothing as yet, but apart from the injury to feelings, which is quite substantive, but apart from that, we have nothing as yet. I know the civil service across the water are having a look at some things to do with part-time and stuff like that, and also the fact that people were promised, but that's already been tested in court, and in Parliament, actually for the police 3 times, and has been turned down. So we really, I have to say, we really just don't know. And it's an unknown book for which we shall just watch and take a watching brief, because really we can't do anything. It's right across all of the schemes. Various schemes have various issues that they want to raise.
Yeah, I appreciate that. I suppose, yeah, it just was something that I was mindful of. And like you say, it's the different schemes and even maybe even different individuals that could come as it rolls out in different ways. But I just don't know how prepared departments are in terms of being ready for potential, but I suppose it's the unknown. But thank you. I suppose there isn't a clear answer to it. I appreciate it.
I think, Sinead, it's fair to say that any questions that have come up, we have either fed them back to the Home Office or to the Treasury. So anything that has come in from members or anything that has come in from maybe any of the staff associations, we are working with the Home Office and the Treasury to try and get answers to some of these questions. But frankly, they don't seem to have the answers at the moment either.
Yeah, thank you. And I think if my reading of it's right, is it true to say that a lot of members won't actually know the fine detail until it's all presented in a way to, the calculator online or circumstances unravel or unfold, where they then contrast what they might have had or what they're being, it just seems...
There's certainly an element of that. We have produced a guidance document for members which is due to issue. It has issued. Which we hope has brought it down in sort of very basic language and takes away some of the mysticism with it. But there is a lot of still unknowns about it, and freely accept that's just what we're having to live with at the moment.
I would say there is an advantage to officers in that the people in the 88 scheme, after 30 years, they couldn't have accrued any more pension. Yeah. But now they do have that choice if they wish to work on. I mean, if you think of an officer, if he joined at 18, he would be retiring at 48. And nowadays that, I wish, yes. But, if he wishes to work on, in the past, he would have literally been paying a pension to mark time, if you want to put it in those terms. But now he can go on and accrue more pension for as many years as he wishes to do so. And there is that advantage to this scheme. In 2015, they were not permitted to do so, but with this court case, they are being permitted to do so. And there is the other incident, information that we do have is that the PSNI have advised us that actually this year, at this time of year, there are fewer officers leaving than there were this time last year. And they have only had 2 opt-outs, one from the 88 scheme, and that was because somebody has reached 30 years and doesn't wish to proceed, but maybe they're retiring shortly anyway. And the other one is in the 2006 scheme, and they don't know why, but it could be for any number of reasons. They don't collect the reasons why if they don't want to record it.
Thank you. I suppose the challenges won't come from the advantages, however, but thank you, and thank you, Chair.
Sure.
Thank you, Sinead. Lynn, it would be useful maybe, because if it was possible for us to get a copy of the guidance or the document that you mentioned that have been produced. I saw one that, and I know where you have maybe seen it, I saw one that the Fire Brigade Union has recently produced. Now obviously it'll have a slightly of a perspective in relation to what the Fire Brigade Union's view was, but they just produced, I just happened to see it the other day, but I think that would be very helpful for members if they saw what was being provided for by the department. So that would be if that could be provided to us, much appreciated.
Certainly, Chair, we'll get a copy of that to you.
Okay, thank you. If there's any other questions, I don't see anyone else who has any other questions. Can I thank you both for your time and for the information you provided for us and answering our questions today. And we trust that this will come to a conclusion and that we'll see an outcome given the challenges that it has created over the last number of months. Thank you very much.
You're welcome, Chair. Thank you very much.
Thank you. Thank you. Okay, members, can I just put to you, are you content with the proposal for the statutory rule, or if we require any further information or clarification? Content?
Content.
Thank you. Okay, members, if with your indulgence now we will try to make some progress because we have to go into a closed session in relation to the bill, so I want to just try and make some headway if we possibly can. Agenda item 7 is the draft supplementary legislative consent motion on the Police Crime Sentencing and Courts Bill, the draft committee report. You'll find that at pages 58 to 79 of the table pack of the draft for the draft report on the committee's consideration of the draft supplementary legislative consent motion on the Police and Crime Sentencing and Courts Bill, which was also emailed to members yesterday. At our meeting last week, the committee agreed that it was content in principle with the proposal to extend to Northern Ireland the provisions in Chapter 3 and Part 2 of the Police Crime Bill, insofar that they relate to Northern Ireland, and that the commencement of those provisions would be conditional on the Assembly agreement to consider whether the Code of Practice following the public consultation complies with the protected rights and requirements. A draft letter, just to advise members that a draft report setting out the committee's consideration of the LCM has been prepared for agreement. Any typographical or formatting errors in the report will be amended at proofing stage before it is circulated to MLAs and published on the committee's webpage, and any proposed amendments to the report were requested by 10:30 a.m. on this morning to enable these to be circulated in advance of today's meeting. No amendments were received. And I just check with members whether they have any proposed amendments to the final draft report. Okay, I'll put the question then to members, which is that we'll just go through these bit by bit, so if you just bear with us. The title page, contents page, committee membership powers page and list of abbreviations page, and that is listed. Are members content with the title page, contents page, committee membership powers page and list of abbreviations stand part of the report? Agreed?
Agreed.
And in regards to the background section, paragraphs 1 to 6 of the report, are members content that the background sections of paragraphs 1 to 6 stand part of the report? Agreed?
Agreed.
The purpose of the legislative consent motion, sections at paragraph 7 to 10, are members content that the purpose of the legislative consent motion, sections at paragraph 7 to 10 stand part of the report? Agreed?
Agreed.
Committee consideration of the legislative consent motion, I'll put and that's at paragraphs 11 to 30 of the report. Are members content that the committee consideration of the legislative consent motion, sections 11, paragraphs 11 to 30 stand part of the report? Agreed?
Agreed.
And then conclusion section, and that's at paragraph 31 of the report. Are members content that the conclusion section of paragraph 31 stand part of the report? Agreed? Appendices, pages 74 to 78 of the table pack, which lists the lists for inclusion of the appendices 1 to 4 of the report. I'll put the question, are members content that the appendices stand part of the report? Agreed? And then can I seek the agreement of members for myself to clear the draft minutes of this meeting for inclusion at Appendix 1 to enable the report to be finalised? The draft minutes will be replaced by the final version of the minutes once agreed by the committee. Agreed?
Agreed. Agreed.
Also to seek your agreement for the report to be published on the committee's webpage and issued to all MLAs and the Minister for Justice. Agreed?
Agreed.
And then to advise members that the committee staff will notify members when the date for the debate on the LCM has been scheduled. Thank you. That brings us then to agenda item 8, the SL1, the Rehabilitation of Offenders Amendment Order Northern Ireland 2020. And you'll find the relevant papers at pages 268 to 332 and also of pages 81 to 109 of the table pack. The Department of Justice is proposing to make a statutory rule which will be subject to the draft affirmative resolution procedure under the powers conferred by Article 5.4, 6.13 and 8.4 of the Rehabilitation of Offenders Northern Ireland Order 1978. The rule allows for some convictions to become spent after a designated period. Rehabilitation has ended. This means that those convictions do not have to be declared after a certain period of time has elapsed, facilitating ex-offenders applying for work and for further promoting their reintegration into society. During the oral evidence session with the departmental officials on the results of the consultation on the reform and the preferred way forward. At last week's meeting, members requested further information on the judicial review taken against the terms of the existing scheme that was supported by the Northern Ireland Human Rights Commission, and the full list of the consultees used by the Department as part of this consultation. The Department has provided the information on the Human Rights Supported Judicial Review, along with a copy of the judgment. The list of the consultees has not been provided given its length, but the Department has provided the information on the categories included and the specific information on the victims' groups that were consulted on the matter and details of the respondents to the consultation. And this is at pages 81 to 85 of the table pack. So, are we content with the proposal for the statutory rule to amend the rehabilitation of the Offenders Northern Ireland 1978 order to reduce the length of time that it will take for some convictions to become spent and to allow for more sentences to be capable of becoming spent, or is there any further information we require? Are we content? Content? Thank you. Agenda item 9, the SL1, Judicial Pensions Regulation Amendments to Northern Ireland Judicial Pension Scheme to ensure parity with England and Wales counterparts. You'll find that at page 334, 377 of the meeting pack. The Department of Justice is proposing to make a statutory rule to support the provisions in the Public Service Pension and Judicial Offices Bill, which is currently completing its passage through Westminster. The Bill seeks to implement the MacLeod remedy for judges and will facilitate the creation of a new UK-wide pension scheme for eligible judiciary, including eligible members of the Northern Ireland devolved judiciary. The statutory rule will make required amendments to the 2015 scheme in light of the age discrimination remedies in the bill, and also makes technical amendments as a consequence of the 2015 pension scheme being closed to new members from April 2022. The statutory rule would normally be subject to the draft affirmative procedure. However, the Pensions Board for the Pension Scheme for Judicial Office Holders, which is tasked with advising the Department of Justice about the operation of the pension scheme, has stated that it considers the regulations to be minor in effect or wholly beneficial to pensions scheme members, and therefore the regulations can be taken forward by negative resolution procedure. The Minister of Justice undertook a consultation on the Judicial Pension Scheme regulations, and a copy of the report is included in the meeting pack. A summary of the Committee's previous considerations in the proposal to address the MacLeod judgment findings with regards to age discrimination and the reforms of the judicial pensions was provided to the Committee for Finance to help inform its consideration of the legislative consent motion for the Public Service Pensions and Judicial Offices Bill, and is also included in the meeting pack for information. Are we content with the proposal for the statutory rule, or do we require any further clarification? Content? Thank you. The SL1 in reference to the court I always have difficulty. Judicature, I always have difficulty with that one. Non-contentious probate fees amendment, Order Northern Ireland 2022. All the relevant information is at pages 379 to 394 of today's meeting pack. The Department are proposing to make a statutory rule which will correct a previous drafting oversight in the non-contentious fee order relating to the fee charged for the certified sealed copy of a probate grant. The amendment will make the provision for a fee of £14 to be applied in the non-contentious probate area to cover the administrative costs associated with the production of the certified or sealed copy of a grant, and will ensure consistency with the fees charged in other Northern Ireland courts and tribunal service business areas. The Committee has engaged with the Department since being made aware of this issue back in November 21. Most recently, the Committee noted the Northern Ireland Courts and Tribunal Service is still considering options for redress and is seeking further legal advice regarding the period of liable and engaging with stakeholders, with the overall objective to find a remedy which is fair, reasonable and proportionate. The Northern Ireland Courts and Tribunal Service is to provide a further update once the preferred way has been identified. This order is specifically excluded from being subject to the negative resolution procedure. However, the Department is endeavouring to comply with the conventions applicable to the negative resolution procedure. And it's to seek the views of members that we are content to note the proposal for the statutory rule, or whether we require any further information or clarification. Content? Thank you. Two other SL1s, the County Court Fees Amendment Order, Northern Ireland 2022, and the Magistrates Courts Fees Amendment Order, Northern Ireland 2022. And we'll take the next two agenda items together. The relevant information is at pages 396 to 425 of the meeting pack. The Department of Justice proposes to make two statutory rules which will prescribe fees for new licensing applications which can be brought to the County Court and the Magistrates Court as a consequence of the Licensing and Registration of Clubs Amendment Act 2021. The proposals cover applications to specify any part of the premises as suitable for the sale of alcohol, extension applications, repealing of all fees associated with children's certificates, and authorisation of underage functions with conditions met. The rules are not subject to any assembly procedure, and the Department will not be able to comply with the 21-day rule due to the timescale available to the Department for Communities. The Department of Communities plans to implement the second phase of the licensing reforms on the 1st of April 2022. And it's to seek the views of members that they are content to note the two proposals for the statutory rules, or whether we wish to submit any views or comments or require any further information or clarification. Content? Agenda item 13, phase 2 of the review of the Psni injury benefit scheme, a written update. And you'll find the relevant papers at 427 to 445 of the meeting pack. The committee considered a written briefing paper back in June 21 on the phased approach being adopted by the Department of Justice to implement the recommendations of the Northern Ireland Officer Audit Report on the injury and duty schemes for officers in the Police Service of Northern Ireland and the Northern Ireland Prison Service, and the position regarding phase 1, which aimed to tackle some urgent legislative issues in relation to the Psni scheme. Phase 1 is complete, and the Department has now provided an update in phase 2, which includes the launch of a consultation document on any proposed changes in late spring. The Department will brief the committee on any proposed changes on the stakeholder consultation in due course. And it's to ask members to note the current position unless we have any further information or clarification that we require. Agenda item 14, proposals arising from the third statutory review of the legal aid for Crown Court proceedings, costs, rule, Northern Ireland 2005, proposed consultation on the written paper. The relevant papers in regards to this are page 447 to 564 of the meeting pack. The Department intends to undertake a consultation on the initial findings of the third statutory review of legal aid for Crown Court proceedings, cost rules, Northern Ireland 2005, as amended. The rules prescribe the remuneration payable to solicitors and counsel for criminal legal aid work in Crown Court cases, and there is a statutory requirement for the Department to carry out a formal review of the rules at least every 3 years. The Department has set out the key issues to be covered and provided a copy of the consultation document and various impact assessments that have been completed. And it's to ask members to note the consultation unless we require any further information or clarification.
Chair, on that one,
yes.
Can I just in light of the conversation that this committee had on in terms of legal aid in the frame of a 3-year budget, which I know is probably not on the table at the moment. Well, it's not on the table at the moment, but no doubt it'll be something, an ambition that won't be completely lost in any future executive. But I just wonder if this consultation is going to be fully cognizant of that, because that was a big factor. It wasn't just about the level of payment, it was the structures around it, and I think perhaps just an assurance that the Department are going to look at it in that new light.
Okay, agreed. Thank you. Thank you, Sinead, for that. That brings us to agenda item 15, the registered intermediary support in the civil and family courts proposed consultation, and it's a written paper. You'll find that at pages 566 to 609. The Department intends to undertake consultation on the extension of the registered intermediary support to the civil and family courts and has provided a copy of the consultation document. The provision of the intermediaries to vulnerable witnesses in civil and family proceedings was recommended by the Gillen Review of Civil and Family Justice, and the consultation will take the views on the merits of the proposal and how any future scheme should operate and should be brought into effect. Just to ask members to note the consultation unless we require any further information or clarification. Gemma?
Yeah, thanks, Chair. And yeah, it's fine to note the consultation, but I was just wondering on the delivery plan, the modernisation delivery plan. I just noticed that this consultation was meant to be done in the last quarter of 2021. So, and I could be completely missing it, maybe in the plan, but could we have a progress update on the actions in the delivery plan?
Yep, okay, agreed. Members will write to the department and seek clarification. Yep, thank you.
Thank you.
Thank you for that, Gemma. Okay, agenda item 16. It's the Chairperson's Liaison Group draft report on the Strengthening Committee scrutiny, pages 611 to 786. The Chairperson's Liaison Group has provided a copy of a draft report on Strengthening Committee scrutiny, which makes 33 recommendations on a range of areas, including scrutiny, subordinate legislation, pre-legislative scrutiny of primary legislation, scrutiny during the passage of primary legislation, post-legislative scrutiny of primary legislation, availability of members' resources, engagement and innovation, and the role and powers of the examiner statutory rules. The CLG has requested views from the Assembly Committee by Tuesday the 1st of March. So it's whether we want to make any further comment in relation to this. However, what I would suggest in terms of one issue is to assist and improve committee scrutiny if the core remit of Hansard is extended to also include oral evidence sessions on subordinate legislation, budget scrutiny, programme for government scrutiny, so that reports are available to inform the committee responses in these important areas, rather than it being dependent on the volume of plenary and primary legislative business at a particular time. And I think that would greatly assist our staff in terms of how those reports are put together. So I think that if that was one issue that we could recommend to the CLG, that would be much valued. We agreed on that? Yep, thank you. Sinead, and then I think, is Rachel? No, Sinead?
Yeah. Chair, I don't disagree. I don't disagree with the recommendation, but I do think it might be also prudent for it to be caveated with costings, because I know on other committees where we have required Hansard, the resource just isn't there, you know, and they are, like this week was an example when plenary was moved and committees then maybe didn't have access to Hansard in ways that normally would. And I know it is a resource issue, and probably there's a cost associated to that as well. So it may be worth caveating it with, you know, reasonable costings.
Yep, appreciate that. Okay, thank you. I suppose the other comment just is that in terms of all the other elements of the report, I think that we should leave it to, because the parties all have been given the opportunity to respond to this. So any other specific issues that the parties want to comment on, that's entirely up to them to respond. So, okay. Thank you, members. Item 17 is correspondence. There are 7 items of correspondence at pages 789 to 915. And I will draw your attention to one of the items in the meeting pack, and then if there's any other issues that members want to raise. Item 17.5 at pages 813 to 815. The response from the Minister of Health to the Committee's request that steps are taken as soon as possible to address the workforce shortage of social workers. This issue was highlighted during the Probation Board's oral evidence to Committee on the draft budget. The Health Minister has indicated that a review of the social work workforce has been completed, and the projected numbers of social workers needed to meet current and future service demands includes the requirement of the Probation Board. The Probation Board will also be asked to join the board being established to oversee the implementation of the review's recommendation. So I think that we should send a copy of the response to the Probation Board, as they were the organisation that raised this particular issue with us. Any comments? Content? Okay.
Comment? Yeah, I think it's a good idea, because the Probation Board made plain it wasn't just about them all fishing in the one pool, that they were at a disadvantage in terms of the what they were able to offer in terms of salary and conditions. So it's good that they're at the table. Yeah. I think it'll hopefully lead to a fairer outcome. Thank you.
Thank you. Are we content then to action the items of correspondence as set out in the cover sheet? Agreed? Okay. Just one item of Chair's business, I think. It's the Speaker has written to all committees regarding the management of the legislative pressures facing the Assembly before the end of the mandate and the scheduling of additional plenary sittings and the position regarding executive legislation and private members' bill. The letter is found at pages 917 to 919 of the meeting pack, and it's just for members to note. Okay, as item 19, any other business? Any other business? Rachel?
Thank you, Chair, and appreciate this. Let me in on this, and I know I raised it on the floor of the House when we were talking about the stalking bill, but I had wondered if it would be possible for committee to seek some information in relation to the guidance and the training aspects of the protection of stalking bill. That we know we were all in there at, when it passed final stage, and I did raise this, but would be interested to get an update from the department, if available, on the creation of guidance of this Act, and then the training for the frontline officers. And I mean that in Psni, but also for the PPS that the bill does provide for, because really, really important amendment that we got on that face of the bill. Yeah. But what I have concern is just in terms of experience of where committee was kept abreast of all of the guidance on the Domestic Abuse Act and the training, is that we don't know anything about that being rolled out yet. And I know it's just at final stage now, but I don't know if guidance has been created. I don't know if frontline officers have been trained in the creation of this offence, and we don't have that long. My understanding is that the offence will commence the day after royal assent, and that, in my understanding, very little of what royal assent actually means and how long it takes is about 3 months. So could we have a situation by the end of May that this comes into force, and those that are tasked with looking after potential victims and processing say reports and getting people convicted don't know about this offence?
Yeah. I wonder too, should we include the right to the department, would also include the PSNI and ask them for their commentary in relation to it, because we have both perspectives.
Yes, Chair, I think that would be useful, just to see what you know, if they have had anything. Maybe they do, and maybe we just haven't seen it, and that's okay. But it's just a bit concerning. It's a wee bit different. Different legislation, I granted, but certainly a different scenario of what we had whenever we were discussing the Domestic Abuse Act.
Yeah. Okay. Okay, thank you for that, Rachel. Agreed, members? Happy we proceed on that basis? Thank you. Sinead, just want to check, you don't want to come in on this? No?
Agreeing to that. That was a very good proposal.
Okay.
I'd be happy to support that. Thank you.
Okay, members, that brings us to the end of our business. I just want to, one issue, and that's to welcome and to thank Marcus for being with us. Members who are on star leave won't be aware that we had someone from the Education Committee, member of staff, who's recently joined the team here at the Assembly, and he sat in because the Education Committee hasn't been having meetings. No, that's not right. It was appropriate for him to sit in on this meeting today just to see how the committee operates. So Marcus, you're very welcome. Thank you for your patience and still being with us. Members, that brings us to the next meeting of the Justice Committee. It will take place on Thursday, the 3rd of March, 2 p.m, room 30, and also the visit of the PSNI Cyber Crime Unit will take place that morning. And just a reminder to members to let Christian and the staff know if you are still intending to attend, and if you can attend to that matter urgently. We will now bring this meeting to a close, and then we'll go into closed session. Okay, so I just press this button. Thank you.
This is the Northern Ireland Assembly Senate Chamber programme sound. This